My lords, kind leave. Acharya Vinoba Bhave's ashram, established by Jamnalal Bajaj Trust in Bangalore, my lords, sought to be acquired by APMC. After long battle, my lords, the learned single judge has dismissed the petitions, my lords. Now, my lords, 21st, the matter appeals were listed before, my lords. For want of time, it could not be taken up, my lords. 2nd March, the interim order expires, my lords, protection given by learned single judge. Matter is listed on 3rd, my lords. Request for tomorrow, my lords. Please, my lords. Otherwise, the officials will come and run over the property, my lords. That's the difficulty, my lords. We have the previous experience under Land Reforms Act, my lords. They pass the order and the next day they come and take over possession, my lords. Therefore, my lords.
And you are apprehending the action.
That's 3rd morning, my lords.
So 3rd morning is some Monday.
Monday, my lords. Therefore,
Monday
request for Friday, my lords. Please.
Monday
my
will
lords.
do.
Yes, they'll come and take over the property, my lords. And we have filed a contempt petition in land reforms matter. Till date, we have not been able to take possession from the government, my lords. One reason or the other, they are saying possession cannot be handed over. That's why we have to protect our possession, my lords.
On Monday at 11 we take up.
My lords have already posted the matter on Monday, my lords. Please, my lords. The mighty state is against us, my lords.
No, everybody is mighty. You are also equally mighty. At least only we are not mighty.
My lords have all the powers, my lords.
All right, tomorrow.
Please, grateful.
This is a writ appeal, my lord.
If your urgency turns out to be wrong, then we'll be facing consequences. Yes.
This is a writ appeal filed by Mysore City Corporation, my lord, on an order where the corporation is directed to issue kata in respect of B schedule, B kata land, my lord, in favor of petitioners. Similar matters are already active. This is required to be connected with that. Any convenient date.
11th March.
Despite buying this, there is an order by a single judge. They are not awarding the amount. If land is acquired for Devanandi International Airport.
Contempt. It is contempt.
After lapse of 21 years also, they are not awarding the.
Let it go to 17th March.
There is a urgency. Already 21 years is last year.
A lot of matters are there, Mr.
Second.
Not 2nd. 12th March.
Other matter it is yes, matter referred by a single judge to larger country. He is already 78 years.
Then you approach learned judicial, register judicial, not here. Then there is no point in giving memo on administrative side. We'll just pursue, get it.
Lordship, serial number 107 and 108. Kindly maybe post
Serial number?
10-3 as there is a connecting match.
Serial number?
107 and 108.
I'm not sure. So what is to be done?
Kindly post it to 10-3 as there is a connecting match.
10-3.
10-3.
Only 10.
Serial number 33, my lord. Serial number 33.
One by one. Yes, madam. Yes.
Serial number 117. Kindly post this matter for next week. Plenary is
On,
not available.
on,
117.
on which date?
Monday, next week.
Any urgency?
Any date is fine.
It can go to 19th March. Yes,
My lord, serial number 50, my lord, may I request for 2 weeks time, my lord.
50.
50, my lord.
Twenty-fourth March.
Please.
Lord, serial number 32 or lordship?
As requested, yes.
Serial number 33. Kindly have it on next week. Any date.
33. There is a delay. Delay is there. Delay of 202 days. We will issue notice returnable on 28th March.
Lordship, serial number 32 or lordship? I kindly have this matter next week.
After the physical is over, yes.
Number 16.
Today it is listed. Not, today not possible. That we don't, on the same day we don't list. You should have moved the court earlier, Monday.
Serial number 6.
Monday. Election to what? Election to what? Which urban local board?
Then we return.
Tomorrow will be difficult, all late tomorrow. The matters. Matters we get. Mentioned and stamped for tomorrow. Get a separate list.
Serial number 16.
Challenge the advertisement, part of it was issued by the respondent. Single bench decided the matter in favor of the respondent, stating that we have to consider the demand notice as a show cause notice, and within 3 weeks, we have to pay the demand notice amount. Constitutional amendment, leaving of advertisement tax is unconstitutional. And request for tomorrow, because 3 weeks time is expiring.
No tomorrow. 12th March.
Not to take, because the 3 weeks time is expiring tomorrow.
Maybe.
In this respect,
At the last moment, you can't come and pressurize the court. Yes. Then wait, it might come earlier than 10th of March. If you wait and don't seek orders by memo, it might come earlier. If you seek date for memo, you take your chance. We are not saying anything. If you seek a date by giving memo, it will be 10th of March. Decide for yourself.
Will request any short date.
Short a date. From us not possible. Office may post it. We do not know.
There are orders to coordinate bench which says.
We'll set aside if you are right. If you are right, we'll set it. Yes. 10th March. Take the memo. 10th.
my lord, in this writ appeal, a suo motu contempt was initiated.
Which one?
In this writ appeal, my lord, we are appearing with the respondent. So a suo motu contempt was initiated against the appellant, the learned civil judge. So we are stating that they were granted a stay and it was granted without them disclosing all the facts. There was obvious omission of facts, my lord. Therefore, we have filed an IA to recall of order. Therefore, this matter may kindly be heard any day next.
IA in what?
Recall of order. Dated 30/12/2024.
Overall.
This application then to a different judge was assigned.
So IA in the writ appeal. It can go to 11th March.
Serial number 16, my lords, a week short accommodation will be granted. Serial number 16. Origin council is out of station. Serial number 16. Yeah.
What do you want?
Week short accommodation.
No, let it be called. PIL will see what to do. All PIL, yes. Get it listed on any date. Get it listed any date. Yes, and from online, yes.
He mentioned through VC, sir.
Your
Mentioning
lordship,
to
serial number 32, your lordship.
Yes, serial number.
May kindly have this matter next week, my lord.
Pardon?
May kindly have this matter next week, my lord.
Which one?
32, my lord, 32.
32. Then next week will go to 25th of March.
Please, my lord.
Yes, as requested by learned of the appellant, stand out to 23rd, 5th of March. Yes.
That's all.
Serial number 70, my lord. I am for the accused.
70.
I pay a week's time to file reply.
25th March. Inform the other side.
Inform that I will take that.
All at the request of learned of the respondent, stand out to 25th of March, 70.
With permission. The contempt matters, serial number 1, Mr. Ravi HK.
Petition order has been supplied.
Learned advocate Mr. Ravi HK states that the order which is brought under the contempt proceedings today is already complied with. Therefore, the contempt petition does not survive. Full stop. The petition is disposed of as not survived.
Serial number 2, Vaishali Hegde. Complainant, your lordship, they filed their affidavit.
Filing compliance affidavit.
So they deposit the money within 2 weeks. They took a lot of time for the matter after 4 days.
This is otherwise barred by time, barred by limitation.
Yes, your lordship. So before the Supreme Court review was filed, all that was there. And the corrected with contempt is before the protocol number 3.
Therefore, can I request you not to finally call it after 3 weeks? Because they said in 2 weeks they'll do it, I will withdraw it.
Appointment has been approved, my lords, only with respect to the arrears along with interest, my lord. It's, process has been done, my lords, at least it will take 2 weeks' time, my lords. That's all my instruction. When order dated 24th February 2025, the appointment of the petition has been
So
approved.
you are receiving arrears of salary.
Arrears.
They'll be called after 3 weeks, your lordship, if it's done, I will.
My instructions are that by 2 weeks it will be credited, my lords.
From the compliance affidavit filed today by Learned Additional Raghavendra, it transpires that the direction of Learned Single Judge regarding payment of arrears of salary with interest at 6% to the petitioner is yet sought to be implemented by passing endorsement order dated 24th February 2025, which provides that the amount shall be paid. Nothing is stated. Within 2 weeks it is stated here.
No, my lords.
Not stated.
It's not stated, my lords. My oral
As
instructions.
it is
within-
sanctioned by the finance department.
Please,
Therefore,
When you will pay?
process has been already been done, my lords. My instructions that within 2 weeks it will be credited to the account of the
Learned
complainant, my lords.
additional government advocate, when asked about the time within which the amount shall be paid as per the order dated 24th February 25, he stated that it is under process and may take 2 weeks' time. Full stop, stand over to. Twenty-seventh March,
Please, my lords.
within which it is expected that the
Please, my lords.
full and final compliance will be obtained by. the
It will be reported, my
respondents.
lords.
This number 3,
To be listed at 2/3.
TB Harish.
Complaint is the honorable single bench, my lord, I directed the respondent to deposit 1.5 crores along with interest within 4 weeks, 3 weeks, my lord. On which, my lord, the department has preferred an appeal. But in appeal, my lord, there was a conditional order saying that 50% of the amount has to be paid within 4 weeks, my lord.
Notice returnable on 27th March.
So number 4, Mr. Ravi HK.
And order is at page number 23, my lord, the direction was for issuance of cash validity certificate within a period of 2 weeks.
27th March.
So number 5, Mr. Sharath S. Gowda.
Page number 24, my lord. Internal page 9. The chief director that yes, the length of the plea will not be found. The defendant has the position from obtaining the request, particularly the petition will be written and there is no form of the plea.
There is no time limit.
4th week, my lord.
Where is it? 4 weeks.
In the last third line.
Fourth week. Notice returnable on 6th of March. Service by hand delivery permitted.
This number 6, Mr. Ravindran P.
Page number 17,
Which page?
page number 17, of order 41, page number 19, page number 19.
19 years.
For non-compliance of the order in a contempt petition, in a writ appeal, this contempt petition can be filed. As per the direction of this honorable court, the property, market value was directed order to be kept in FD. And they took, given an undertaking that the award will be passed in after limit of 4 months from today. More than 1 year. They just passed a preliminary notification against secretary and nothing is progress. I moved an application for the release of the amount because my lordship kindly see at page number 20. There was a direction given, CC is closed with the liberty for the complaint to seek the release of the that amount kept in FD.
Hmm.
But this honorable court has rejected my AA, so will find it, page number 129.
So,
IA number 2 of 2024 is filed for to the release the amount. that
so
was
what is the
paid
contempt?
on
What is the contempt? What is the contempt?
17, DTMP published a notification under section 14B of the Town and Country Planning Act for requirement of some property for the formation of court. Now, when they try to possibly take possession of the land, I moved a petition for an interim stay was granted. In spite of that, they took over the property. By 2020, they completed the construction, road formation, and it is open to the public.
Right, but which direction is breached?
My lord,
Which direction is breached?
undertaking given.
Where is that? Where is that undertaking?
Page number 19, page number 19.
19.
What of?
Where is that 19?
Page number 19. The NK remained, land and advocate for the accused of filing memo of complaint, so even they think that the total sum of 2,13,91,000 is deposited before this court by way of 3 demand drafts, all dated February 2024, bearing so on to DDs, drawn in favor of the General High Court of Karnataka. He submitted that an award will be passed in an outer limit of 4 months from today. It is even after 1 year, no award is passed. My property is used as a road. The amount is held in. No, until unless, my lordship,
There is no direction to be brought under the contempt jurisdiction.
my lordship, it's an undertaking to.
There is no undertaking given. Let us see, where is that undertaking?
This is that, he submitted that award will be passed in our outer limit of 4 months from today. His submission is placed on record. Memo of complaints is kept on record. They start put the said amount in any nationalized bank for a minimum period with automatic renewable clause. The CC is closed with the liberty for the complainant to seek release of the amount. Now, when I move for an application for the release of the amount, till the award is passed, it cannot be released. That is the order this honorable court has passed. That is page number 129.
What is not passed?
No, I would only, again, for the second time, a preliminary notification, I stated at para number 21 of my petition.
It is the following order passed by a single judge, passed by the ordinate bench on 9th February 24, which is brought under the contempt jurisdiction of this court, under the Contempt of Courts Act 1971, for the alleged breach of the direction. So quote the entire order, small order, page 19 and 20. It was submitted by learned after quoting by learned advocate Mr. Swans who complained that even though committed before the court by way of submission, that the award will be passed within the outer limit of 4 months, no steps are taken even to pass the award, much less for acting upon the other directions. Notice returnable on 1st April. Notice,
Number 7,
same 1st April.
is number 8, the Praveen HP.
Number 13, my lord, the report order, my lord, wherein, my lord, the accused was directed to dispose of the application, my lord, within 10 weeks from the date of order. Plus 17 September was the date of order. My lord. Each page number 13, my lord, is the operative portion of the order.
3rd April. Notice returnable.
Seal number 9, Mr. Srinivas V.
Page number 10, my lord.
2nd April is holiday.
Honorable Court has directed the complainant to consider the representation. Page 10, ma'am.
Notice written 2nd April.
Number 10,
For the petitioner, the complaints are in the Murad is not there now, they relieve from the court. But the court has directed not to review the petitioner, page number 205. The similar petition that they have taken back, not the petitioner. Not now, this is petitioner working, not this is examination period, not the review meeting.
You are continued or not continued?
I'm not continuing.
Where is the ever?
No, annexed 205.
No, no. Where is your statement in your contempt petition that you are not continuing?
But the patient, in my place, not the other petitioners, other candidates are posted. Other in my place, not other candidates are posted.
You are not continued. Where is the statement?
Mirror this, not take, the review from court, given. Kindly see Milord, page number, 8, Milord. Page number 9, paragraph number 8, Milord.
Para number 8.
Milord, complaints are, similar petition, Milord, the complaints are working in this, second has allowed their, Milord, the.
This is indirectly
Oral-
relieving.
Relieve house. Relieve, Milord, because in my personal, other candidates are posted, Ashok.
You show that you are relieved,
Relieve, Milord, because other candidates are posted in my place, Ashok.
not in indirect state.
Kindly, directly, Milord, because of kindly see orders, Milord, kindly see the order, Milord, in my post, Milord.
Any order is passed, shows.
Milord,
Any order of relieving you is passed?
Milord, kindly see the annexure, Milord, the, Milord, the page number, Milord. Kindly see the page number, 225, Ashok.
That's right, 220E, annexure.
Milord, see.
Same, we are on the same page. Read.
Milord, kindly say annexure B2, Milord, all are working, Milord.
Who are you?
Annexure B is,
Srimati Shailaja.
yes, no, she is Shailaja. Now she is Shailaja, second, Milord, all petitions, their identity cards, Milord, are produced, Milord, annexure B, Milord, in B series. Milord, kindly see this, C, Milord.
It may not.
D and D, kindly say D, annexure D in my place, Milord, the candidates are posted, Milord, in my place, Milord. In my place, the transfer as posted, transfer petitioner posted, Ashok, in my place.
Who will be answering your case?
Ashok,
Who will be answering your case?
uh,
Who is the contesting respondent?
condition is second respondent, Ashok. Second respondent. Christ Lordship, Karnataka Residential School, Lordship, second, number second. Similar situation are taken back, Lordship. Similar situation are, kinds are taken back. Now I am the candidates, Milord, they are not allowing me to work, Milord. Kindly see.
With reference to what is provided in official reminder dated 3/1/2025, to break it page 225 from annexure, break it over. It was submitted by learned advocate. It was submitted and stated by learned advocate Mr. So-and-so, the complainant, that the petitioner is relieved from service by virtue of the aforementioned order, which amounts to the breach of one directions of learned single judge, which prohibits the relieving of the petitioner from service. Notice returnable on.
Now examination period is reading, Milord, examinations, in March is the examination. The similar petitions coming on 7th, Milord. 7th March.
18th March on the return full stop, on the returnable date, the respondents and in particular respondents, in particular respondent 2 shall state before the court whether the petitioner is relieved or not. Whether petitioner is continued in service or not. And whether he is relieved by virtue of the aforesaid reminder, order.
Milord, date.
If you are wrong,
Lord, they're relieved, Lord, that's why I come before.
Next.
Still number 11, this Sharath is good.
That's all for complaint. That's single judge's order is at page 10, my lords.
2nd April.
Please.
Still number 12,
That's page
So my-
28,
sorry.
my lords had passed an order. Page 28. In a contempt petition, whereby my lords, they had undertaken to, the relevant portion is at page 30, saying that within 2 weeks, revenue entries will be,
2nd April.
that's gonna have an earlier date. I tell you, but then my lords, I have a reason why I'm requesting. I understand the burden on the court, my lords. It's a matter, my lords, pending from 2012. Now, my lords, it's a third round of contempt petition. My lords may have it in the first week or second week of March. It's only, they have to only affect the revenue entries.
20th March.
Please. Lords, I may be even permitted to serve the accused by hand.
Service of notice by hand delivery is permitted.
Grateful, my lords.
still number 13.
My lords,
Naveen
I
Chandra
appear
Bhai.
for the petitioner. My lords, this is the matter that is referred back by the Honorable Supreme Court that within 6 weeks to be completed. The other day, my lords, we mentioned it and we took a common date for today. I'm ready. My lords, I'm for the petitioner. If my lords just sees the cause title, I'll just explain to my lords. Contempt petition has been filed by me, the father, and the 2 writ petitions are filed. 6121 is by the mother challenging the family court order, and WP 10508 is filed again by the father challenging the family court. Now, my lords, I have 2 or 3 days back filed an additional set of documents. If my lords could confirm that it's there on my lords' files. It's an IA to bring additional documents on record. Since the last interim order, many developments have taken place.
This is matter where the father is some.
Yes, the 2 children, mother is in Goa, father is here. My lords recollect
that-
the
Oh.
old one. Last year, my lords had passed an order. Thereafter, my lords, we went to the Supreme Court. Supreme Court directed status quo. And now finally,
Ask the party not to stand.
Please sit.
Yes.
Yes, my lords, I have just to, I have filed an IA with some additional documents. I just want to make sure that additional set of documents.
So what is the order of Supreme Court and whose?
Yes,
You went to Supreme Court?
I went to the Supreme Court. In that additional set of documents, my lords, the last Supreme Court order is there. On the last page,
The 30th January?
30th January order, my lords. May I just read it out?
Yes.
Yes. On a specific query as to whether children are with father or with mother, it is informed by learned counsels on both sides that children are with father and are presently residing at Bangalore. Since the present petition arises purely out of an interlocutory order passed by the High Court on 8/4/24, we direct that the High Court shall decide the contempt petition as well as the writ petitions on their own merits as early as possible and preferably within a period of 6 weeks from today. Till the High Court decides the matter, the orders passed by this court regarding maintenance of status quo at the first instance on 10/5/24 and was directed to continue thereafter shall continue to operate. So 10/5/24, when the
So
children,
status quo means the.
children were with the father.
The father.
Yes. So from May of last year,
Now, what is the age?
now, my lords, the children are, there are 2 children, a boy and a girl.
Yes.
In fact, can I just hand over just a summary of the list of these?
Now, which is we go in the reverse direction, which is the order which was taken to Supreme Court
Yes.
or order?
The order taken to the Supreme Court, my lords, was the 8/4/24 order of my lords.
8/4/20.
8/4.
All right.
May I just read that out? That will be on the file of my lords. Yes, 8/4/24 order. May I read that, my lords? The contempt petition as
Not-
well.
Not necessary.
From para 6 onwards, the
Yes.
directions were given.
They are studying at Goa or Bangalore?
No, they are here. Now, in fact, may I just
Because
point?
we have stated that the following the arrangement is
Yeah.
directed, the children are permitted to be taken by mother to Goa
In fact, that was, may I just request my lords
to
to go
attend
to?
the classes to be held until the vacation commences during the first 2 weeks. So at that time, the children were at Goa or? Bangalore?
No, may I submit at para 4, my lords may just read para 4. They were taken away on 1st December
The
23
Regular studies are going on where?
in Bangalore. From the academic year of 2023, 22, 23, they were in Bangalore. 23, 24, they continued in Bangalore. 23, 24, 25, now they are still admitted in Bangalore and continuing the schooling.
That
And
is
I want to
because of the
show,
interim order, my lord. The children had been enrolled in a school in Goa by the mother, and because of the proceedings that were filed, and they had custody of the children for a short period, thereafter, my lord, he has enrolled them again back in the school in Bangalore.
in fact, my lords may just see para 4
Mother
of
is-
the same order.
Mother stays at Goa.
Mother left Bangalore and went to Goa. She was living with me. Kindly see, in fact, para 4 of the same order.
Before we proceed further.
Yes,
This is the order which was
stayed.
stayed by the Supreme.
Yes. And at,
You stated that the children are at Bangalore.
yes, at
So
that time,
in that context, the status quo is granted.
yes, yes,
Now, what was the order which was under contempt?
yes. Now, my lords, the order under contempt is, my lords, may I refer to 2 petitions or 2 paper books which my lords may refer to for ease. Contempt petition, my lords may refer to, all the documents are there. The order is at page 47. Page 47 of the contempt petition. This was an order filed in a GN guardianship petition filed by me. Kindly see, my lords, petitioner is the father. And I had filed a petition seeking guardianship and custody of the children and interim custody of the children because she had forcefully taken them away. Now, my lords, may I read out the relevant portion?
They are studying in which? Tiago Monte. They are studying which standard?
My lords, they are studying presently in standard 2 and 3.
2 and 3.
Yes. The daughter is about 8 years and the son is about 9 years old. Now, may I refer to ink page 76 of the order. Ink page 76 from para 35. From para 35. May I read out from there? This is the reasoning of the judge, not the statement of facts. This is how the judge reasons. 35. By relying on the facts of the case and documents on record, the counsel for the petitioner argued that children are 7 and 8 years old. This was last year, my lords. On 25/11/23, an incident occurred in the house at that time. One Jaya Aditya, my lords, he is a neighbor, if my lords recollect. He was a neighbor of the parties. They were living together in a gated community. This person is a neighbor and a man in his 20s, much younger than the respondent wife. He is found in their bedroom in a stark naked condition with his wife, with the respondent. in the bedroom with respondent, and prior to that also there were many incidents regarding communication between the respondent and the said Jaya Aditya. When the respondent was found red-handed, immediately she left the matrimonial home and she booked only her tickets and not the children's tickets, because the incident happened on 25/11/23. She left the house on 26/11. 26 November, she disappears alone, leaves the children. At that time, children were in the school. After 4 days, she comes back along with her mother on 1/12 and takes the children without the consent of him and his parents. She comes back on December 1st. And when the father is not at home, he's at work, only his parents are there, she forcibly takes away the children. Thereafter, he has communicated with her. She has filed a false complaint against him before the Goa court. He appeared before the court and he filed applications for visitation and to take the children to Bangalore for the sports day as well as the birthday. Children were studying all along in the Bangalore school. The
So
honorable,
this incident is reported at the house of the third party.
no, house of my house, our house. We were living together without any difficulty. There was no complaint of domestic violence filed. Nothing was wrong.
You all three were living.
All four of us, that is me,
I want to
my
make one
wife.
submission, Lord.
My lords, let me
Let-
complete.
let-
Let me
I
complete.
have
Even my children were in
submission
the.
and I'll make, otherwise I won't make.
Yes.
My learned friend is arguing a writ petition against the order of the family court. I have filed a writ petition earlier. She files it later. It has been served on us a few days ago, email only. We haven't responded to that yet. I don't even know what exactly she's seeking in that. Therefore, my lord, I would like to file my statement of objections to her writ petition.
I have no difficulty.
Yes, I have not yet been filed anything. It served on us a few days ago. But if she wants to argue, I'm ready with my case, I will argue.
There are cross petitions.
Cross petition.
Yes.
All
The family
matters have
court
to be
made
argued.
an order giving me custody.
No, family court has
Sorry.
made an order giving me custody.
Giving them custody and with visitation rights to me. That is what I have challenged.
And what you have challenged?
Family court gave an order giving me custody of the children till the completion of the academic year, because the children were taken away in the middle of the academic year of 2023 on
So
1st
at the
December.
time of the order of the family court, the children were at Bangalore?
Yes, yes. And on 1st December,
an
the
order.
children were forcibly taken away. I am challenging it, saying it should not be limited to the academic year, full interim
There's
custody.
an order of the Goa court, my lord, which says the children are in Goa and they should not be disturbed.
My lords, either I argue or my friend takes time to file a reply. I have no difficulty either way. If he wants to respond to my writ and he wants time, I have no difficulty. If my lords are hearing this, also I have no difficulty.
Our order, which was subject matter of contempt, related to arrangement during the vacation?
No, my lords, great respect. The order in the no, my lords, the order which is subject matter of contempt is the family court order, because
No.
Sorry.
Our order, which was
Yes.
taken to Supreme Court,
Yes.
dealt with handing over of custody to mother during vacation or otherwise?
No, with great
Mother was
respect,
permitted to take them to Goa.
mother was
It was
permitted.
during vacation period or some?
No, at that time, she provisionally admitted the children for some 2 weeks in Goa. So at that time they were taken, then they were brought back. They continued their academic year, because here the academic year in the international school continues till June. Then they came back and continued their schooling because the academic year was still going on. In fact, their academic year was disturbed, and that is why the family court said, you have disturbed the academic year, hand them over till the completion of academic year. We challenged it to the extent that it should not be limited to the academic year. Throughout the GNWC proceedings, till the final proceedings, children should be with me because they were always here. That is my petition. If my friend wants to file a reply, I have no difficulty. Here are these copies. List of dates. You've given it? No, you've given it, right?
It's a boarding school.
No, no.
No, no,
Not
no.
a boarding school.
It's a day school.
Scholar.
It's a day
It's
school.
a day school, is it?
It's a regular Bangalore International School. It's one of the most well-known and
Goa was boarding school.
Goa. No. Even the Goa was also a resident day school.
Wife's parents, my lord, mother lives in Goa. She's originally from Goa. And that is children are born in Goa. And then the couple shifted to Bangalore.
Then let-
Couple
For 3.5 years, they're in Bangalore,
2021.
Lordship. For 3.5 years, they're in Bangalore.
From 21, they are, in fact, I want to just show my list of dates. I have just handed over a brief list of dates that my lords can see.
Under the given circumstances, probably we should put them in a boarding school. It's good for the kids. You both can lead your life the way you
The
want.
children are with the father and the grandparents.
50% holidays, both of you can take it with the
Children are-
condition that you are not going to poison the mind of the child. It is better if the kid is brought up, kids are brought up in the boarding school, they will be better citizens of the country and better human beings.
In fact, children are
Rather
with the-
than with the type of parents they are born to.
Lordship,
in fact, children
may I
are with
submit,
the
Lordship?
father
Can we?
and grandparents, and mother is visiting in the house of the father every day. We are having no difficulty. Every day she comes and spends time with for an hour, and we are
I
definitely.
think that's a better solution.
Certainly, my lord.
And probably the court also let it invest its time for deciding better commercial disputes and things of national importance.
My lords, where the children are taken away like this.
Anyway, we won't,
Lordship,
ultimately, we won't harmony.
No.
nothing else.
We have that faith. We definitely are in
So,
the hands of my
My
lords.
client was willing to come to stay in Bangalore. My lord. She has nobody in Bangalore. Her mother lives in Goa. And so when she went, there was a domestic violence event that happened. That's the reason why she went. Of course, that is refuted. But now, my lord, since the children are, she had the children, she admitted them to a school there. By virtue of these interim orders, my lord, they were able to get the child back here, readmitted him. He says he took a loan to pay the school fees. He has produced documents for that. So apparently he also is not of a great means. Now, if my mother has to come to live in Bangalore, she has nobody here. So even we said, make arrangement for me to stay because marriage is not annulled. So the husband's duty to maintain the wife is very much there. Let him maintain me, let him provide for my accommodation
He has
here.
to file
Now,
vacation.
now there is no vacation. There'll be no vacation.
Oh, now school is going on. Now school is going on.
So
Yes,
vacation
Lord.
in June.
Vacation is in June.
June.
So school is going on. They are in
Hold-
grade 2 and 3. They are very much.
File your.
Goa curriculum is slightly different, my lord. But now they are in Bangalore.
No, this is, why this order is limited to the,
To that year,
you
that
said it
academic
is
If-
limited.
The family court order.
Huh.
In fact, that is the only point we are challenging, that why should
Where
it
is-
be limited to the academic year?
Where is that?
Yes, my lords, the operative portion is at page 80,
Five.
85, 44, 84 onwards, 84, para 44. Para 44, therefore, in the interest and welfare of the children, this court feels that till completion of academic year of the children, they have to reside with petitioner and he has to take care and responsible for the children and education. Respondent being mother is entitled to visitation rights. Kindly see the operative portion order. The respondent is hereby directed to hand over children Master Tiago Monte de Silva Sidhu and Miss Inez Monte de Silva Sidhu to the petitioner for completion of their academic year education at Bangalore International School, Bangalore. Respondent is given visitation rights on Sunday whenever she wants with prior intimation. During
The operative part, it is not mentioned.
no, till the completion of the academic year.
Very good.
Till the completion. That is why we challenge saying it's vague. It should not be till the academic year alone. It should continue. That is our challenge is to that extent. It should not, because what is going to happen after academic year? Again, the children will be disturbed if they are shifted.
Let
Yes.
Mr. Nagana, you want to file a
Yes,
reply.
Lord, I want to file reply to their.
But only thing that keep in mind the Supreme Court's time bound direct.
We'll need only 4 or 5 days.
Do it on 5th of March.
5th is fine.
Please.
Grateful.
Since learned senior advocate Mr. Nagananda takes time to file reply on behalf of the respondent wife to the main Remain to the writ petition from stand over to 5th of
5th of March, great.
Could it be on 7th, my lord, if your lordship please?
My lord.
Pardon?
10th if possible.
7th.
5th and 6th.
7th, just one minute, okay. I'll just
Or 4th.
confirm.
Lordship, can it be on the 4th of March or the 10th of March, Lordship, if possible?
4th is
Because-
fine, if 4th is convenient.
4th, if possible, Lordship.
Not possible on 4th, my lord.
Because I would like even the instructing counsel for who appeared in the
6,
Supreme
only our consensus will, 6 week will be over by
by
2nd week of-
15th.
Lordship, the Supreme Court said preferably 6 weeks. Supreme Court said
Got the
preferably
order.
6 weeks, and they
Because
were
we
so
want to
long. They
assist
took so
my
much
lord.
time to mention the case before your Lordship.
You can
We would
interpret the
have,
Supreme Court's language, we can't enter.
No, Lordship, I'm only saying that the intent,
We are
it
bound
is
by, we are
preferably,
respectfully bound.
and in fact, we were arguing they're seeking time today also, Lordship. We are only seeking if it's 4th or the 10th, Lordship.
Kindly have it on 5th, my lord, both of us.
4th or the 10th, Lordship, if possible. 5th, Lordship is saying, because even today I couldn't be there, Lordship, because of,
Doesn't matter, you are always welcome online.
no,
You are for whom, Mr.
Lordship, I am for the petitioner, because I
Assisted
was
me. He
representing
was
the case in the
counsel
Supreme
in
Court.
Delhi when the matters
Yes.
went on in the
Yes.
Supreme Court.
So 5th.
Or
Can it be on
or
the
even
4th, Lordship,
7th
if
is
possible?
okay if you prefer 7th.
No.
7th is also okay, 5th or 7th,
Whatever you-
either way.
7th is better.
7th is also
Okay, Lordship.
2:30.
2:30.
7th, Lordship.
2:30, yeah, 2:30.
Yes,
So that it is certainty of taking.
Yes,
Yes.
great.
Great.
Is number 14? Mr. Vaishali Agde?
In this matter, my lords, the Honorable Apex Court has stayed the matter, my lords.
Yes.
Honorable Apex Court has stayed the matter, my lords, not to proceed.
What is this?
This is a matter pertaining to the release of iron ore from the Bellicary port, my lord. So, the
17.
issue involved the surety, my lords, whether a surety for a like sum should be given or not. So they have taken the matter in an appeal. So the matter is likely to be, will
So
be listed
appeal-
on the 7th of
Appeal
March.
appeal against the main order.
Please, my lords, on the order which is in the contempt petition, my lords.
Order under contempt.
Please, my lords. The next date was on 7th March, my lords. It was posted on 17th February, my lords.
Lords may kindly have it after 4 weeks, my lords, so we'll explain the matter.
There's no survey for consideration.
My lords, proceedings are stated, it will be listed on the 7th of March. So thereafter,
Proceed, so we can't even discuss.
we will expedite the matter before the Supreme Court, my lords, and thereafter my lords can take a decision.
In course of the hearing, it was pointed out by learned additional government, Mr. Raghavendra, that in respect of the order which is judgment and order which is brought under contempt petition from a special leave petition and with the criminal bracket over diary number 3940 of 2025 has been filed before the Honorable the Supreme Court, in which from on 17 to 25 following order is passed. In that view, the present contempt petition is adjourned. Full stop. Either of the side is at liberty to move the court for placement of the contempt petition
Please,
at
my lord.
appropriate stage, by filing a note before the registrar judicial.
Please, my lords.
Grateful, my lord.
Oblige, my lords.
Is number 15? The Naveen Chandra V?
This was 14. Both
My lords had heard this matter and reserved it for orders. If my lords recollect the teachers' contempt, where the teachers were for children with disabilities. And their
2:30.
2:30? Today, my lords? Great.
My lords, my colleague Pramodin was appearing this matter, my lords. I waited 2 weeks, my lords. After 2 weeks, my lords.
Why it is kept for orders?
Orders, please, my lords. I thought it was a further
Great.
hearing, my lords.
30 will
Please,
be-
please.
Great.
This still number 16. Murli there, Echa.
For the petitioner, my lords, kindly seek for a short accommodation, my lords.
Why?
Council is out of station, my lord.
What is it about?
Lords, I have not perused the records, my lords.
When you
Monday.
when you ask for time in any matter, you must read it. If you want to argue, then don't read, we will read it.
Sorry.
But when you ask for time, you have to read it. Because we don't read when you ask for time. We only read when you argue. So when you argue, don't read the matter. Take an advice from me. Whenever you argue in future, any matter full place, don't read it. The judge will read it. But when you are seeking time, you don't know about the matter. How can we grant time to a lawyer who don't know the matter? which
File is with the
seeking?
arguing council.
PIL is there for acquisition. All day. Now you are smiling. When do you want?
My lords, any date next
7th
week.
April. As requested by learned advocate for the petition.
This still number 17. Mr. Samant BS.
Madam, may be permitted to withdraw the petition.
Why?
Already similar issue dealt by the single judgment. Already identical issue has been dealt by the single judgment. With respect to the handing over of investigation to the CBI probe.
On 4/11/24, this court had an occasion to pass the following order. And fourth this order. Today when after quoting, today when the petition comes up for consideration, comes up again, learned comes up again, learned advocate Mr. So-and-so the petitioner, Mr. Savant VS files a memo of withdrawal. Stating thus, quote memo of withdrawal dated 27/2/15, stating this. So this directly reflects on your bona fides. The council. Your withdrawal request directly reflects on your bona fides. Either way. And changing stand before court of law.
But with respect to the similar matter, the handing over of the investigation to the CBI probe already filed by some complainant matter before the learned single judge. That is came to be dismissed. Since we have no merits, that's why.
Then why did you file this?
Minutes.
Why did you file this?
No, we are not aware about that filing of the.
We are not ready to believe that.
This is not only with respect to the scam, minutes, with respect to various scams. Last time your lordship directed to.
Since this is PIL, and since there is an order passed on 4/11/24.
On the last date, minutes, your lordship.
Asking you to do something.
Please, minutes.
And you are, instead of complying with, coming out with a different kind of request. We'll take a call in the next week.
Please, minutes, on the last date, minutes, your lordship is about to dismiss the
10th
petition.
March. Read our order.
Minutes.
You as a public interest litigant, never serious about the matter.
Minutes, we solely rely.
Not about we are not concerned with the matter. You are not serious about your own conduct.
Minutes, we solely relied on the
That
paper
that
publication.
factor will take into account whatever order we pass. And we come on you very heavily, mind well. If this is the platform you are using of public interest petition and changing the stand, changing the color as a petitioner in the subject matter before the court, in your submissions, in your stance, withdrawal, pressing, filing, cursorily filing. So mind well, if you are appearing or a senior appearing, we will take a very stern stand on your conduct whenever the matter is taken up. 10th of March, give back to memo to be given back. We'll take a call what to do. We will not permit you to use the platform PIL in such a fashion. And if we find good, we'll pursue the PIL on your behalf.
On the last occasion, my lords, we solely rely.
We find good, we'll pursue. We don't need any debate.
Please.
We know what you are saying.
My apologies.
Everything is open before us and before you also. Yes.
Please.
Seal number 18 to CO Gerale.
For petitioners counsel, my lord. Now, this is a matter where, my lord, PIL has been filed, my lord, challenging the action of the state, my lord, appointing my lord, a committee, my lord, without any statutory basis or anything, my lord. This totally contravention of, my lord, Article 309, my lord, and 164 1A, my lord. They have been given the status of, my lord, cabinet minister, and, my lord, there is no educational qualification fixed, there is no experience fixed, nothing. Simply for the purpose of, my lord, implementing certain government scheme, cabinet, my lord, rank of cabinet minister has been given. They have appointed, my lord, Annexure A, my lord, on the basis of a note by Chief Minister of the state. This, my lord, the government order has been issued. And pursuant to that, my lord, they issue certain, my lord, clarification and, my lord, further orders, Annexure B and C. And thereby, my lord, they appoint, my lord, state level committees, my lord, and district level committee, and then taluk level committee. My lord, this is a totally, my lord, contrary to constitutional scheme and arbitrary at the other hand, my lord. And the backdoor entry, my lord, what they cannot do directly, my lord. my lord, the coordinate bench has, my lord, already struck down the Parliamentary Secretaries Act, my lord. Now they are, those who have been given, my lord, the cabinet rank. Now, my lord, by way of this, my lord, certain party workers have been, my lord, given with the power of a cabinet minister. And it is a loss to the exchequer. My lord, they will meddle with the administration at various level with the executive, my lord. They will be, my lord, now allowed to sit with the development, my lord, the meetings at the various level. This is, my lord, an indirect approach adopted by the state, my lord, to interfere with the executive by way of political intervention. Now, my lord, the state has to give protocol, my lord, and deploy, my lord, all facility they have to give. This is totally a burden, my lord, at the cost of exchequer. The remuneration is also fixed, my lord. And no basis, either for appointment, their control, whether what is the status, no check mechanism. Who is the regulating authority? Nothing is there. Simply they have created these posts, my lord. Can understand, my lord, if they have appointed
No, this
certain
is
nodal
some-
officer from the executive who is in the state service.
Some state level guarantee scheme is floated. Shakti. In that, the vice chairman, chairman and members are appointed. Where is that cabinet rank, etc.?
My lord, cabinet rank has been, my lord, provided. Annexure E. But at page 35. Page 35, my lord. Cabinet rank status to the chairman of the state committee. Then, my lord, 5 numbers of state minister. At page 35, my lord. Annexure A, typed copy, translation at, my lord, 35.
35. Any
Yes,
of the factors explained.
Yes, my lord. There is a typographical error, my lord, that chairman has got the cabinet rank status.
It is there.
My lord, state level guarantee schemes implementing authority
It is there, cabinet.
in the table. Lord, that is the chairman has been given, my lord, the cabinet rank. Vice chairman's, my lord, they have the minister of state rank.
They are the party workers?
They are the party workers, my lord. There is no qualification.
MP, MLS.
No, not MP, MLS. They are party workers. No educational qualification, no experience. And that is in all level, my lord, district and taluk level.
If you come to 28, which is in Kannada, I think it's better if you look at it.
Please, my lord.
Page number 28.
Yes, my lord.
See, it contemplates formulation of a committee for implementation of the guarantee schemes.
Yes, my lord.
Promised. Now that committee consists of Sachiva Samputa Darjaya Sthanamana Hondidavaru, meaning that persons who are having a cabinet rank status, the government also has to clarify, does it mean a new person will be appointed and he will be conferred the rank of cabinet rank, or an already existing person having a rank of a cabinet rank will be appointed as the chairman?
I'm grateful for this question, my lord. This is, in fact, a confusion, my lord. But what they have done is they have appointed somebody.
No, that
and
has
given
to
the
be
status.
clarified. That's most important. Because reading of it shows that a person will be appointed as
Yes, ma'am.
chairman, only if he is having a cabinet rank status.
Yes, my lord.
That's how the language is. It doesn't say that a person will be appointed and he will be conferred cabinet rank status.
But as a matter of fact, my lord, they have appointed the ex-MLA, my lord, to this
Okay.
ex-minister, MLA.
And he is
And
conferred.
he has been
cabinet-
conferred with the cabinet status.
Where is
Is the
that order?
unfactual aspect.
Where is that order?
But that order is not available, my lord. They have not supplied, my lord. We applied through RTA
You
also.
have stated in the petition,
Yeah, we have stated, my lord, we have arrayed them as a party also, my lord.
arrayed them party.
Yes, my lord. The chairman is, my lord, respond number 4 at page 20, cost title. These are all the vice presidents, my lord. In fact, my lord, they have even go to the extent of appointing committees to the district and taluka level. All party workers have been accommodated.
This is what?
This is a state committee.
No, this is some scheme is floated.
My lord, they have implemented, they have, my lord, come up with some guarantee scheme, freebie scheme, my lord, basically.
They are freebies
Yes, my lord. For implementation of these freebies, my lord.
in the nature of revenues.
According to him, these are freebies.
My lord, the respondent number 4 is, my lord, is the president. He has been given cabinet rank. Then, my lord, the state minister rank, respondent number 5, 6, 7, 8. Lord, there is no cabinet, my lord, resolution or, my lord, decision taken. It is purely on the basis of note by the chief minister. Honorable chief minister has issued note. And based on that, these annexure A, B, C, my lord, they keep on going and appointing. And in fact, my lord, annexure A does not say who is the appointing authority, who is the controlling authority, or who is the disciplinary authority if they do something. Obviously, my lord, this is to meddle with the executive. Lord, if they really wanted to implement the scheme, Lord, they could have appointed the officers who are working in the state cat by either KS officers, IAS officers, or the concerned officers of the department. This is totally a, Lord, the parallel system they are creating, Lord. And they are interfering in all district level, taluka level, and state level meetings. And they are giving instructions to, my lord, the executive.
Now, these 3 annexures A, B, and C are in respect of different schemes.
No, my lord, this is in continuation. Annexure A is the first, my lord, order issued. Then in continuation of that annexure B, my lord, they keep on, my lord,
This is a common order in respect to all schemes, different.
Yes, my lord.
District level guarantee schemes implementing authority.
Yes, my lord.
Then there will be state level also.
Yes.
State level.
And taluka level.
So for all schemes, this chairman is common.
No, it is
Scheme wise appointment or common?
Scheme-wise or common. Common. But there is no clarity, my lord, but
There is no clarity. That is why we are asking. Hard learned senior advocate, Mr.
Arun Sham. Arun Sham.
Arun Sham. Yes, Arun Sham. Sorry for not remembering. I can't remember because of the difficulty in the nature of name remembering, not otherwise. Even after 1 year, it is my ready comment.
No problem.
Assisted by learned even so and so petitioner. And learned additional government advocate, Srimati Nilofer Akbar, who has with her copy of the petition served in advance. The present is a public interest petition. Fair enough. The petitioner who hails from the Kudachi village in Rayabaga Taluka of Belgaum district. stated to be born in the family of agriculturist, having the degree in Bachelor of Science, and served as police sub-inspector, is also police officer in the district of Belgavi, Devanagari. It is pleaded that out of public spirit, the present petition is filed. It is the case of the public interest petitioner, inter-alia, that present governmental dispensation, which negotiated and fought the last Vidhan Sabha elections in the year 2023, had in his election manifesto announced Sarva Janagada Santiya
Sarva Janagada
Tota,
Shantiya Tota.
which was kind of high guarantee schemes named Graha Jyoti, Graha Lakshmi, Anna Bhagya, Yuva Nidhi, and Shakti. Full stop. By these 8 schemes, it was promised to the people 200 units of free electricity to all houses, rupees 2,000 every month to every women head of the family, a fixed kilogram of food grains to every person in the BPL family every month, and rupees 3,000 and rupees 3,000 to 1,500 for 2 years to unemployed graduates and unemployed diploma holders. It was also promised that free travel to all women throughout the state in the regular in Karnataka State Road Transport Corporation and Bangalore Metro Transport Corporation buses would be availed. It is the case of the petitioner paragraph. It is the further case of the petitioner that by promising the schemes which according to the petitioner were the guarantees in the nature of freebies, the party which published and announced such manifesto won 132 seats in the Vidhan Sabha, and government was formed. Be that as it may, full stop. The issue relevant to this petition is the nature of challenge. What is prayed is to, what is called in question is to, what is called in question. Where are your relief?
Page 16.
Are the government order dated 25/1/24 and 2 other consequential orders dated 24/7/24 issued by the respondents, issued by respondent government. They are the orders whereby in purported implementation of the schemes aforementioned, the government has proceeded to constitute state level guarantee schemes implementing authorities, district level guarantee schemes implementing authorities, as well as taluka also there.
Yes, my lord, Taluka.
Where is that taluka? District level, then three nahi hai aapka. Third is not there. And BBMP guarantee schemes implementation committee in 28 assembly constituencies, for 28 assembly constituencies. It is not clear as to whether the impugned orders of notifications are issued in common in respect of all these schemes, or it relates to a particular scheme.
Preamble says, my lord, all schemes.
The
Page
preamble of the orders, however, indicates that they are the common orders whereby the chairmans, whereby the authorities as above are sought to be created for the purpose of all these schemes. Paragraph. It could be seen from the contents of the notifications order that whether it is so this is status is given only in respect of state level.
Yes, my lord. Chairman and my lord, the vice chairmen. The chairmen are
But
given, my lord, the state.
not for district level.
No, not for district level. They have been given,
It
my
could
lord,
be seen
remuneration and other
from
benefits.
from the contents of the impugned order of notification that as far as the state level guarantee schemes authority is concerned, chairman, vice chairman and member are indicated. Chairman, vice chairman, member and member secretary are indicated to be the part of the implementing authorities. Full stop. What is sought to be highlighted is that the chairman is indicated to be one with cabinet rank status, the vice chairman is shown to be with state minister status. According to the submission of Government Senior Counsel for the petitioner, those who are appointed as chairman and vice chairman are neither cabinet ministers or the ministers with state or the state or the minister with state. The appointees are made respondents. Who are they? 5-2, 4-2.
Only party workers.
4-2, 4-8. Who are they?
But they are all party workers.
They are the vice presidents of the.
Who are stated to be the
Vice presidents of the committee, my lord.
Respondent number 4 is the chairman, my lord, others are vice chairman, vice president.
Political workers of the same party. Given the chairmanship or vice chairmanship, vice chairmanship, or membership, as the case may be. It is the case that these appointees are conferred with the benefit of cabinet rank status or the state level minister supposed to be a status in terms of pecuniary benefits from a salary and perks. Salary, pecuniary benefits and perks payable to them. Learned Senior Council submitted that not only the kind and nature of appointments and the manner in which it is done is highly objectionable, the appointees are going to play a pivotal role in implementing the schemes which are perceived to be of great, of high public, of public importance and public benefit. It was submitted that looking to the educational or technical qualification of the appointees with such benefit of cabinet or state level ministers, would on the contrary operate counterproductive to the public good and public interest. Besides that, their appointment with cabinet rank facilities or state minister rank facilities offends the constitutional provisions and principles, in particular those reflected in Article 164
and 309.
What is that 309? And 309 of the Constitution. 164.
Recruitment and conditions of service of persons serving union or state.
They are not serving service.
Lord, their services have been taken, my lord, by way of,
They are
there is
not in
no
service
scheme,
of
there
the
is no law, my lord.
164. You pressed Article 309 in your submissions. Hmm, 309, where is 309? This is the services under union. This will not apply. It can't apply.
They have been, my lord, it is a, I'm trying to say, my lord, it is a backdoor entry, my lord, giving complete go by
You
to
can
3.
develop in your argument if you can. This is not the
Please,
service
very
under the state. The court has noticed the contents of the impugned order, public notification, whereby such appointments are made, whereby such persons are whereby the appointments are made as implementing authorities of the schemes. The court has further considered the pleadings. The court has, read it. Read it, what is that? The court has. As well as the pleadings in that regard, to come to a prima facie view that if the petitioners finally, the petitioners in ultimate analysis turns out to be true, petitioner, in ultimate analysis turns out to be true in his case, subject to, however, the stand which may be taken by the state government, the things portrayed, portrayed, depict unwelcome state of affairs. Provided they are right and you what subject to your state.
Where is the cause of action, my lord? I really don't understand that. I can understand. My lord, I can understand if they had brought in at least, my lord, one incident.
We have so and so contents of the pleadings, on prima facie consideration, the court is inclined to solicit a reply from the state government. Notice returnable on.
Obliged.
Lord, let them not, my lord, officiate, my lord, till then.
When that matter is kept?
My lord, 28th March.
27th March.
So 28th, alas. 27th.
March.
Obliged.
Obliged.
Learned additional government advocate accepts notice on behalf of all the respondents.
No, my lord. I accept notice for
Except 1
respondents.
to 5.
1 to 3.
1 to 6.
1 to 3, my lord.
1 to 3.
4 to 6 are private. 4 to 8.
1 to 3.
But you will not produce any official communication.
We will produce, my lord, in the meantime, my lord. We have read, my lord, but we have applied also. Place it on record.
My lord, that was my first defense. They haven't produced it.
They have arranged them as a.
Yes, yes.
So that
And
is.
I have mentioned
Yes.
the date of appointment also, but it is not available.
No, everything is available.
It is not.
Place it, my lord.
It
Try
is
to
not
get-
that is less.
No, my lord. Prima facie, I thought. I will defend the order, man. There's no issue.
Yes. Let us.
Obliged.
Obliged.
Yes.
See, seal number 19, Mr. Ravi Shankar. I have furnished the copy of the resolution. Last time, the Supreme Court directed me to produce the resolution.
This is
copy.
also PA.
Yes, my lord.
Where is the resolution?
I have furnished the resolution copy.
Where is that? Filed it by memo.
Memo.
Yes, see it in 7. You shut down the crushing unit. Because of the pollution.
Same body is there.
Now body is changing,
And
but member is the same.
it is
The body means members are same, but president is changed. 17 members, they are same.
council members are irrelevant. It is the body which constitutes a person, the Gram Panchayat. Member may go on changing. So you are producing a resolution of a body which is not currently in existence.
Currently existing.
So how can you mislead
The
the court?
president is not.
How can you mislead the court in this fashion?
Election president is.
How can you mislead the court in this fashion? Producing a resolution of an earlier body and claiming authority on that behalf. Tell us, we are going to impose a very heavy cost. How can you mislead the court even after order in black and white? You first answer this, then proceed for your arguments. We are not going to tolerate this kind of misleading to the court. And hoodwinking, you are here hoodwinking the court, Mr. Counsel. How can you produce a resolution authorizing of the earlier body?
The earlier body means.
On the ground that the members are same?
Members are same.
What kind of argument you are advancing before the High Court and the first court?
My lordship, members
As
are
a public
same.
interest petitioner?
My
Now
lordship,
call up, now tell us what cost should we impose?
here, my
What
lordship,
cost we should impose now?
the
Tell us.
president has been changed.
We want an answer from you, what cost we should impose. We are not inclined to proceed anything further. This is too much, Mr. Counsel. It is good that my brother has drawn the attention. Resolution of 22 in respect of petition filed in 24, that to an earlier body, saying that I am authorized to file as an individual capacity
Meanwhile, they
on
have.
behalf of Panchayat. What kind of bona fide you are showing for yourself?
Meanwhile, they have in annexure, as per annexure DD, they have submitted representation to the various authorities.
Now
They
tell us
have
what
not taken
cost-
any action.
Now we want an answer, what cost you will impose. We
The
want
president
from
is
your-
changed now,
we want
but
from your
members
mouth-
are same, my lord.
We want from your mouth what cost we should impose. Otherwise, we will impose.
People, the villagers are suffering, my lordship, because of this mining activities, illegal mining activities, people are suffering. And sumoto action may be taken, my lordship.
Now, who is the president of the Gram Panchayat today?
President will be. All of is previously Kempegoda was there. Now is the now Alappa is.
When the elections took place last time? Last election took place when?
Previously Kempegoda was there.
The last election to this Panchayat, what is Panchayat is there?
Yes.
Panchayat,
Gram Panchayat.
Gram Panchayat. Elections took place when? Or the body was,
Election took place
or the body was reconstituted when?
on 10/12/2024. It has been. My lord,
10/12?
this-
So this petition is nothing except misleading the court on every front.
Election year 2020, my lords. 30/12/2020, the election certificate has been issued to the petitioner.
Pardon?
30/12/2020,
30th.
the election certificate has been issued to the petitioner. Renukappa.
You are asking that the
So even this does not permit them to file a case, sir. Not only that, even the resolution does not authorize the Gram Panchayat to file a case. They have not resolved the case. Asking the question, sir. The authorization also, I mean, the resolution also, whatever that you have passed, has not resolved to file a case before the court.
ಅಲ್ಲಿ ಆಕ್ಷನ್ ಮೇಲೆ actually take action ಅಂತ ಹೇಳ್ತಾರಲ್ಲಿ. There was a discussion on the issue of building stone quarry and
We really appreciate your calmness.
my lords.
We really appreciate your calmness in making us exasperated. So you tell us what course should be. We also will be calm and cool now, learning from you. What course we should impose? What is thoroughly misleading the court and hoodwinking the court? Tell us. Think it over by the time we conclude our order. Time is short for you to think also.
Please.
Yes, tell us what. Tell us what course should be imposed. Styled as public interest petition. The prayers which came to be advanced was to direct the authorities to stop the building stone mining and crusher activities in the vicinity of Kolagatta village in the land survey number 49/1, 49/2, 55 and 65. Order dated 2/1/25 in this regard was prayed to be set aside. The petitioner is described as Gram Panchayat, Lokamannahalli, Turuvekere Taluke, Tumkur district, and represented by its member Renukappa, RENUKAPPA. Since the paragraph petition was filed on behalf of Gram Panchayat and the petitioner projected himself to be the representative of the Gram Panchayat, on the last occasion, court had asked learned counsel for the petitioner. You are senior counsel? You are a senior counsel?
No, my lords.
Learned counsel for the petitioner. Good. Learned counsel for the petitioner. To whether the petitioner has got any authorization on behalf of the Gram Panchayat to institute the public interest petition in the name of Gram Panchayat. Which is a body constituted under the statute and the constitution, under the constitution, the statute themselves. Learned advocate for the petitioner was entirely at his receiving end to admit that at least for the present, no such authorization was produced on record. Paragraph. In that circumstances, the court had an occasion to pass the following order on 13/2/2025. Then quote the order. Today, when the petition came up for consideration after quoting again, the court asked learned counsel about the compliance of the last order. Full stop. In response, it was pointed out that memo is filed furnishing copy of the memo dated 14/2/25 is filed furnishing copy of the resolution passed by the Gram Panchayat. along with the memo, figures the copy of Gram Panchayat in vernacular language, as well as the translated copy. Full stop. It is in respect of the general meeting held on, it is relatable to general meeting held on 14/2/2022. Whereas, to be noticed, the petition is filed in the year 2024 on 13/12/24. Full stop. It is stated in the minutes that the general meeting was held on 14/2/22 at 11 AM in presence of the President, Mrs. Nalina J. Two aspects, paragraph, were readily admitted on behalf of the petitioner. Not only that, they definitely and specifically come out from record. Firstly, the resolution is of the year 2022, when, as accepted by learned advocate for the petitioner, a different body was functional in the Gram Panchayat. Admittedly, as on today, it is a different body than one whose resolution is produced on record, claiming that thereby the petitioner was authorized to file the public interest petition. Public interest petition on behalf of the Panchayat, Gram Panchayat. The other stark aspect which is coming out is that on bare reading of the aforementioned resolution dated 14/2/22, it nowhere refers to the authorization given to the petitioner to institute any petition, much less the present petition. Full stop. The above tale-telling facts show that the petitioner has not only misled the court on all fronts in filing the petition, in projecting himself to be a public interest petition, and in claiming bona fides as public interest petition. Not only the petitioner has misled the court, the entire filing of the entire way of filing and submitting the petition and the facts amounts to laying a deceit with the court. Full stop. Noticing the sorry state of affairs and the total lack of bona fides on part of the petitioner, this petition is dismissed with cost of ₹1 lakh to be paid within 3 weeks to the Karnataka.
Remote action may be taken because of people are suffering in the vicinity of the Kolkata village.
Pardon?
People are suffering in the vicinity of Kolkata village. The sumoto action may be taken on the available records, on the basis of available records.
So what do you want? They are poor people.
Lordship.
Petitioner is a poor person. Petitioner is a poor person.
Poor means he is having land, agricultural land, is doing agriculture.
Not poor.
agriculture, he is doing agriculture activities.
So it is poor or not poor?
He is a farmer, my lordship.
Agriculturists of this country are poor or rich?
So poor.
Poor, poor.
Please, my lordship.
At least some question you must
Please, my
answer, Mr. Counsel. We understand that you are not able to answer any question about your bona fides. But this question is about your personal thing. You are poor or
No,
rich?
he is poor, my lordship, because
Poor.
he is a farmer.
At this stage, learned advocate, for the petitioner stated that the petitioner is a poor agriculturist. In that view, the cost is reduced to 75,000.
My lordship,
We can't tolerate this type of filing of petition and wasting the time of the court.
my lordship, here, the president is changed now, presently, president is changed, but for the members are same members, 17 members, they have passed the resolutions. The 17 members were present at the time of,
In the resolution, there is nothing to authorize you.
my lordship.
In the resolution, there is nothing to authorize you.
Like, it is not authorized but to unanimously, they have decided to take the action in respect of the issues in the vicinity of Kolkata village. Because of farmers' crop were destroying, because of farmers, the photos crop were destroying, the roads were, public roads were deteriorated. Kindly see the photographs of this, my lordship. The entire atmosphere, entire environment is, they have spoiled due to running of the illegal mining. They have obtained the, without having any license, is running the mining. And moreover, my lordship, kindly see the order of annexure, annexure Q, my lordship. He obtained the annexure T, my lordship. You obtained the order from this honorable court by referring this.
You want to argue the petition?
My lordship.
You want to argue the petition?
No, my lordship.
Then we are ready to hear.
Because of the villagers of suffering, that's what.
So, you want to argue the petition?
If permits.
All right, argue it and face the consequences. We are not here to waste the time, Mr. Counsel.
Please, my lord.
Yes.
Seal number 20. Sridhar Prabhu.
Yes, what is this? Hope not Gram Panchayat. We hope it is not a Gram Panchayat.
No, that's I.
Yes, what is
But I
it?
request a lot
What
of
is it?
permission to argue because my friend on record is not well.
Yes,
So,
yes. Anybody?
But annexure A is the impugned order. One of brief facts leading to this petition is that the government has decided to withdraw 43 prosecution, which are launched against various persons, including rights and attempt to murder. Before I start on merits, I had filed a petition before the learned single judge, which was withdrawn with the liberty to file a PL. I'm sorry, it is not part of the pleadings, but okay, sure. Not under the scheme of CRPC 321, the government has no role, to advise or even direct withdrawal of the prosecution. It is the domain of public prosecutor and the concerned jurisdictional court. Now, please see, the impugned order at annexure A, page 42.
This 321?
Yes.
Here, please. Now,
321 CRPC.
now these cases were withdrawn when?
No, this is, the government now has passed an order directing a prosecutor to withdraw the cases. Now, government has no role to play in this
And
entire
this
scheme.
new act will apply or this CRPC?
It's the old act. There is no change in the BNSS and the CRPC so far as 321 is concerned.
But let us refer to
321. BN, yes, 321. 174. public prosecutor or the assistant public prosecutor
Read it.
in charge of the case may, with the consent of the court, at any time before the judgment is pronounced, withdraw the prosecution. Any person, either generally or in respect of one or more of the offences for which he is tried, upon such withdrawal, if he is made before the charge is framed, the accused shall be discharged in respect of such offence or offences. If it is made after the charge is framed or when under this code no charge is required, he shall be acquitted in respect of such offence or offences, provided where such an offence was against law relating to any matter to which executive power or union extends, was being investigated by Delhi Special Police Establishment under the DSPE Act, or involving misappropriation or destruction or damage to any property belonging to the central government, or was committed by a person in service of central government while acting or purporting to act in discharge of official duty. The prosecutor in charge of the case has not been appointed by central government. He shall not, unless he has been permitted with the central government to do so, move the court for its consent to withdraw the prosecution or the court from the conducting consent. Direct the prosecutor to produce before it the permission granted with the central government to withdraw the prosecution. Now, my lord, so far as this section is concerned, my lord, role of government is not contemplated. Role of the state government is not contemplated. So far as this withdrawal of cases is concerned, this has been held by the apex court in number of cases. Now, please see Annexure A, page 42. Under Annexure A, page 42, my lord, the government directs for withdrawal.
1 second.
Yes.
Next, sir.
Annexure A, my lords, page 42 is the order of the government which is impugned before your lordships. Page 40, in page 42, my lords.
Yes.
Government has given approval to withdraw the prosecution from the prosecution under section 321 CRPC in total 43 cases mentioned in annexure registered in various police stations of the state. Now, surprisingly,
They are the cases against whom?
well, certain politicians, writing cases, and all list is enclosed. Now, the surprisingly, my lords, law department rejects the proposal.
No, have you got the list of cases?
Yes, my lords, I have produced that annexure. Page 55 onwards is a list of cases. Now, my lords, before that, may I draw page 55, my lords, is a list of cases. Now, before that, my lords, may I draw your lordship's kind attention to page 53. 52 is a cabinet note.
Yes, 53.
53, if your lordships were to come to serial number 4 on the right-hand side, Police Department, Department of Prosecution, and Government Litigation and Law Department have been consulted. Their opinion is obtained. They are of the opinion that these cases are not fit for withdrawal.
1 second. What you are reading?
My lords, I am reading at page 53, my lords.
Yes.
This is a cabinet note.
It is.
My lords, serial after financial implication under the heading of interministerial consultations.
Yes.
The Police Department, Department of Prosecution, and Government Litigation, Law Department were consulted. Their opinions were obtained. They are of the opinion that these cases are not fit for withdrawal. Now, in the teeth of this,
So according to you, this was initiated by at the level of the state government.
state government, it is only the learned public prosecutor of a particular case who can, after going through the case, my lords, has to make an application to the concerned court.
Is there any modalities or guidelines framed?
My lords, Honorable Apex Court in SK Shukla's case. Copy of it. Just pass. This is, I'm referring to 2006 1 SCC page 314. But similar matter is pending before your lordship's my lords at page 43 annexure B, where the previous dispensation, when it wanted to withdraw around 61 cases, this court has issued certain guidelines. My lord, I'm referring to annexure B, my lords, page 43.
But then
Yes,
it was not PIL.
no, it was a PIL.
It was a PIL.
Yes, it was a PIL. 12,755 my lords.
So what happened to this?
My lord, this is pending, and your lordship would kindly come to page 44. The order of the Honorable Division Bench. My lord, the similar cases were quoted. Then, my lords, the Division Bench would direct that in keeping in mind the parameters in VC Shukla's case, SK Shukla's case, my lord, the state government is bound to act. This is a PIL where, my lord, they wanted to withdraw against a certain member of parliament and a member of legislative assembly. Paragraph 32, my lords, in the SK Shukla's case, para 32. That page 334. May I read?
1 second.
Yes.
Page
My lords,
32.
334, paragraph 32.
Yes.
This petition is filed against an order passed by the state government dated 29/8/2003, whereby a public prosecutor was directed to withdraw quota cases against accused persons. An application moved by the prosecutor for withdrawal of these cases before the special judge, though no order was passed permitting withdrawal of these cases. However, in view of our finding in SLP so and so, we cannot affirm the order of the state government for withdrawal of these cases and consequential application made by the public prosecutor for withdrawal of the cases. The order passed by the state government dated so and so, as well as the application moved by the special public prosecutor before the special judge Kanpur Nagar cannot be sustained, and accordingly, order passed by the state government and application moved by the special public prosecutor before the special judge Kanpur, both are rejected. In this connection, our attention is invited to Shoding Paswan versus State of Bihar and so and so. In these cases, it has been laid down that public prosecutors has to shoulder the greater responsibility for withdrawal of the cases under 321 CRPC. In Shoding Paswan versus State of Bihar, it has been held that settled law laid down by the Supreme Court has been that withdrawal of cases from prosecution is an executive function of a public prosecutor, and ultimate decision is to withdraw the prosecution is his. Before application under 321 of the CRPC is moved, public prosecutor has to apply his mind to the facts of the case independently without being subject to any outside influence. Government may suggest public prosecutor that a particular case may not be proceeded with, but nobody to compel him to do so. However, Section 321 CRPC does not lay down any bar on public prosecutor to receive instructions from the government before he files an application under that section. If the public prosecutor receives such a contrary, public prosecutor cannot file an application for withdrawal of the case on his own without instructions from the government, since the public prosecutor cannot conduct a case absolutely on his own.
But the Supreme Court said that is
no advisory, yes, my lord.
Permissible for the public prosecutor to receive instructions from the state government.
But now the state has directed them to withdraw. It is not, kindly see the annexure A. State directs them to withdraw, and my lords, kindly see the further paragraph, my lords. The public prosecutor cannot act like a post box or an act. But now under annexure A, they would direct them to withdraw it. Lord, without recourse to any of the guidelines issued by the Honorable Apex Court. These cases involve series of destruction of public property and rioting and attempt to murders.
Then one more stage is to consent of the court.
Consent of the learned jurisdictional court. Yes. Now, my lords, the order passed by the division bench in Annexure B is that the public prosecutor is independently to examine and decide if he is willing to do so. But Annexure, the cabinet note includes that my lords, may I draw again, your lords, page 53. They have already said that they can't do it because these cases are to be proceeded with. Page 53, my lords, your lordship. Police department, department prosecution, to which a public prosecutor belongs to, which conducts the prosecution. They say that they are not fit for withdrawal. Page 53, my lords, serial number 4. Once the prosecution department itself says that it is not a cases for withdrawal, how could Annexure A be passed?
Where is Annexure?
My lords, Annexure A is the order of the government which is impugned. Now 53 is the department's opinion. The police want to prosecute. The Department of Prosecution wants to prosecute. Law Department.
Which are the cases? Which
My
are
lords,
totally
that would, my lord would find it
nature
at
of
page
offences?
55 onwards.
Nature of offences. Under some forest related.
Yes. Not only forest, my lords, the writing of case, Hubli rights cases is also part of this list. Assault on police, destruction of public property. Lords, translation copies at page 85. '96 is one example, if your lordship would kindly, page 96, serial number 6 is one of the case, which my lord would kindly consider.
Yes.
That's column number 2 are the list of offences. Page 96, serial number 6. But these types of cases are being withdrawn. Where, my lords, the law department and the prosecution department would say that don't withdraw it, we want to proceed with the case.
What is 353 IPC?
My lords,
Writing.
no, my lords, it's 353 is obstructing a public servant for discharging the official duty. Causing a grievous hurt. Formation of unlawful assembly, my lords, and writing are 143 to 149. But ultimately, state can tell him, but not force him. It is for him to decide. And unfortunately for the state government, now 53 shows that prosecution department has rejected this proposal.
Or learned senior advocate.
No, my lords, I am not.
Or learned advocate. Also for the petitioner. We're appearing.
I appear.
And learned additional government advocate Srimati Nilofer.
Respondents
Service
will
of
learn.
copy of the petition in advance. The public paragraph. The public interest petitioner hearing. Then advocate. Enrolled with the Karnataka State Bar Council. Who, by filing the present public interest petition, has sought to espouse an issue, public cause about as contended by him. Decision on part of the one state government enforcing the public prosecutors concerned to withdraw the criminal cases which forcing the public prosecutors to in breach of section 321 of the Bharatiya Nagrik Raksha Samhita 2023. This is number
CRPC. Under the old law. T21.
321 of the Code of Criminal Procedure 1973. It is the case of the petitioner inter-alia that several criminal cases have been registered with different police stations across the state of Karnataka between the year 2008 to 2023. Out of these cases, it is submitted, 43 cases are selected to be withdrawn from the prosecution. It is the allegation that these 43 cases these 43 cases involve highly influential personalities such as former ministers, members of legislative assemblies, residents, and other persons holding the high positions. The challenge is directed to, the prayer is to set aside. Where is the prayer?
Annexure A, my lords, prayer.
The prayer is to set aside.
Page 29, my lords. Petition.
Government of Karnataka order dated 15/10/24. Passed by the competent authority of the Home Administration Department, Indian Times, which deals with the withdrawal from prosecution cases under section 321 of the Code of Criminal Procedure. The order reads as under. You have to quote in the entire order. Full stop. Section 321 of the Code, section 321, CRPC. It reads as under. It's in Code section 321. Full stop. A reading of the aforesaid provision would indicate that a public prosecutor or assistant public prosecutor in charge of a case may, with consent of the court, at any time before the judgment is pronounced, may withdraw from the prosecution of any person. The submission is that the discretion to withdraw the case from prosecution lies with the public prosecutor to be examined on case-to-case basis independently, and the withdrawal can be effected with consent of the court. It was submitted that it is the public prosecutor or assistant public, it is the opinion of the public prosecutor or assistant public prosecutor, as the case may be, would weigh WIGH in justifying the withdrawal of a case from prosecution. Decision Paragraph. The decision of the Supreme Court in S.K. Shukla versus State of UP, into bracket 2006, 1 SCC 314 was placed into service. More particularly for the observations made in paragraph 32 thereof to submit that it is settled law that the withdrawal from the prosecution is an executive function of the public prosecutor, and the ultimate decision to withdraw from prosecution is his. It contemplates application of it is observed that before an application is made under section 321, the public prosecutor has to apply his mind to the facts of the case independently without being subject to any outside influence. It is observed that the public prosecutor cannot act like a post box to act on the dictates of the state government. Full stop. Having relied on the aforesaid observations and the text of section 321 CRPC itself, it was highlighted by learned advocate of the petitioner that the public prosecutor department, where is that page 53? The police
Page 53.
department, the Department of Prosecution and Government Litigations and the Law Department have already opined that the cases which are sought to be withdrawn as per the government order dated 15/10/24 are not fit for withdrawal. Full stop. In this regard, cabinet note, a copy of the cabinet note into bracket file number :HD 129 MHB 24 was produced, which dealt with the subject number C:5782024. Full stop. Dealing with the very subject of withdrawal of the criminal cases registered in the various police stations in the state, it is stated in the said cabinet note under the title Inter-Ministerial Consultation, thus, then quote at page 53 this. Therefore, even though the opinion given by the Department of Prosecution and the Law Department that the cases are not fit for withdrawal, the impugned government order dated 15/10/24 was passed, reflecting a decision of the state government to withdraw the cases from prosecution. Full stop. It could be learned advocate for the petitioner is prima facie justified. Correct. Learned advocate for the petitioner is prima facie justified that the government has been exerting its dictate to the prosecutors in ordering them the withdrawal of the cases from prosecution, which is in clear breach of section 321 CRPC as well as the law laid down by the Supreme Court. It was submitted that when the Department of Prosecution and the Law Department has refused in their opinion, stating that the cases are not fit for withdrawal, the state government has exceeded its authority, to say the least, in passing the impugned order. Full stop. A strong prima facie case is made out.
Great.
There shall be notice to the respondents returnable on 11th March.
Lords, may I make one request? Lords, annexure A, Lords, maybe
11th March is too early.
Lords,
Make it 17th March.
My lords, may I make one request? Annexure A, my lords, if they implement, then my lords, the accused will go out and I have to make them parties. It will lead to, my lord, all I am requesting is this. Lords may kindly consider. My lords, annexure A can be suspended, but with the liberty to the prosecutor to examine independently and.
You don't have the trust on your courts.
Not that.
Then
My lord,
the
I.
court is still to apply the.
My lord, this is not, I never intend
So
to say
the
so.
courts where the cases are pending have to apply bind in terms of section 320 before permitted.
Wait.
So we can't prejudge the
I'm sorry.
reply, if any, shall be filed by. You can show this to order to the
Very well.
courts where
We'll do that.
cases are.
Great.
pending. No court will permit withdrawal.
I understand.
Once
I
the
follow.
PI is pending.
Yes. We follow.
And if the court permits, it will be at the perils of the court also.
We follow. Great.
It's number 21, M. Manjunath.
List of for the petition. Yes, what is it? This PIL. What is the amendment?
The amendment is, last may kindly see at annexure E. That is page number 175.
175.
The short amendment. May I read that one? Short statement of objection reasons. Amendment Act 13 of 2024. Page number 175 annexure E. Statement of objection reasons. It is considered necessary further to amend the Karnataka Government Parks Preservation Act 1975. Karnataka Act 23 of 1975 to make a provision for provide
Yes.
So may I read the amendment? The page number 175, annexure E.
Yes, what is that amendment?
Amendment is, it is considered necessary further to amend Karnataka Government Parks Preservation Act 1975, Karnataka Act 23 of 1975, to make a provision for provide 2 acres of land for the purpose of development of upper terminal point under Nandi Hills Ropeway project on public-private partnership model for a period of 30 years. The next page, 176, that is the insertion of clause G to section 5. Section 2nd, amendment of section 5. In the Karnataka Government Parks Preservation Act 1975, Karnataka Act 23 of 1975, in section 5, after clause F, the following shall be inserted, namely, 2 acres of land is survey number 3 at Nandi Hills for the purpose of upper terminal point under Nandi Hills Ropeway project on public-private partnership model for a period of 30 years, the boundary details they have given. Pursuant of this amendment, Annex F is the order.
Project is permitted. Ropeway is
Ropeway project
is permitted.
Nice. So pursuant to this amendment, the Annex F is the impugned order.
Where is that impugned order?
Annex F 177 page number. I read this one. Subject regarding transfer 2 acres of land in Nandi Hills from the Horticulture Department to the Tourism Department for the purpose of the upper terminal point of the Nandi Hills Ropeway project under the public-private partnership model being undertaken by the Tourism Department. Read. Proposal. Nandi Hills is a famous tourist destination in the state, visited by thousands of tourists. The Tourism Department is developing a ropeway for passengers in Nandi Hills under the public-private partnership model to provide a fast and eco-friendly transportation system. This will save time in reaching the Nandi Hills and provide a scenic aerial view of the surrounding area. The construction of the ropeway will improve connectivity and attract more tourists to Nandi Hills. This area is owned by the Horticulture Department of the Government of Karnataka. Proposed area is protected as a garden under the Karnataka Parks Conservation Act 1975. The Director of Horticulture has submitted the proposal mentioned in Citation 1 above to exempt 2 acres of land in Nandi Hills for the purpose of the upper terminal point of Nandi Hills ropeway project from the purview of the Karnataka Parks Conservation Act 1975. As per the meeting held on 5/1/2024, under the chairmanship of the Minister of Higher Education and District in charge of Chikbalapura regarding Nandi ropeway, it was directed to transfer 2 acres of land in Nandi Hills from Horticulture Department to Tourism Department for the purpose of constructing the ropeway as mentioned in citation number 2 above. In this regard, Department of Parliamentary Affairs and Legislation has implemented the proposed area through the Karnataka Government Parks Conservation Amendment Act. The said area is to be transferred from the Horticulture Department to the Tourism Department. Therefore, following order is issued. The government order number so-and-so dated 20th to 8/2024. Based on the details mentioned in the proposal, the Director of the Horticulture is permitted to transfer 2 acres of land in survey number 3 of Nandi Hills from the Horticulture Department to the Tourism Department for a period of 30 years.
So what is objectionable?
Well, objection is that the Nandi Hills is having a unique biodiversity features and flora and fauna. To preserve the biodiversity features of the Nandi Hills, the ropeway project
This is
is
also
going
got
to have a disastrous impact on the ecosystem of the Nandi Hills.
any study, any.
That is a matter. That is,
Because this is itself for development of Nandi Hills.
no, development may be taken.
And the development of tourism.
No, not development, not at the cost of the nature.
To show some basis, not.
The last may kindly take into the page number
Page number.
1 minute. Annexure B, a glimpses of Nandi Hills.
That way everybody knows.
Ah.
That itself doesn't.
Because biodiversity is facing the threat today. Then
Yes, madam, what do you do?
Lord, I'll take instructions coming up for the first time.
We are not really convinced.
you also may kindly look into the annexure, yeah, that is an annexure. Where we can get the whole details.
Sir, if we go by your logic,
No, not logic, my lord.
no, listen.
Tell us.
Outskirts of Bangalore,
Yes.
we have instances where tigers were hunted by the Britishers. You could not have had Jainagar, JP Nagar, anything beyond Jainagar. If we go by this logic, preserving flora, fauna and other things, Bangalore growing beyond the Kempegowda towers, beyond this Lalbagh probably south.
Yes.
Uh,
My
You
responsibility.
should not have grown, according to you. Now, Nandi Hills is not part of Western Ghats. Anywhere in Deccan Plateau, where there is no human activity, there is you are bound to have some flora fauna coming in.
No, the another phase of this Nandi Hills is that it is the origin of the 5 rivers, my lord.
Correct.
Kavati, Chitravati, other 3 rivers.
They are not
And this-
disturbing it.
This project is coming under the foothill of the Nandi Hills, that is the buffer zone limits of the Arkavati river. That is a violation of the buffer zone limits of the government. That is what you are questioning it. And this impugned amendment is violation of the so many environmental laws and guidelines laid down by the Honorable Apex Court on the Godavaram case with regard to the sensitive area of the biodiversity.
So this Nandi Hills comprise of how many acres?
Well, 2000 and odd is what?
2000
Yes,
and
big-
3
big-
acres are,
There are range of hills, my lord, range of hills.
only 3 acres are.
Only 3 acres here sort of comes in the buffer zone limit.
Just,
Lord, and I think the project is implemented because they have
just
made the,
just highlight the concern which is.
very well.
I think you should be caring for rejuvenation of Arkavati River in
Yes,
Kengeri,
Interlinking of the 5 rivers.
which we have made it into a gutter right now.
Yes, sir, real, my lord. You can't see where is Vrishavati, where is Arkavati in Bangalore.
8th of April.
Much. One Scottish physician, my lord, Dr. Francis Buchanan Hamilton, who served as a bearded botanist, served in the British East India Company, he was the first European to describe the flora and fauna of the Nandi Hills, recognizing its unique biodiversity. It is a part of a close pet granites. At that time only, he recommended to the East India Company to declare the biodiversity area one of the World Heritage Site Studies. Much obliged. Very grateful.
Right, man.
This is number 22. Shivprasad Shantangoda.
Let's appear for the petition. Let's seek a short accommodation.
Pardon? Why it is old matter? Will give.
My lords, on the previous hearing, my lords had heard the matter and expressed to post the matter for orders.
This for what? Demolish the building.
Yeah.
My lords, matter pertains to encroachment of building on road area by respondent number 9.
This one number 9. Who is 9?
Private party, man. Private.
Private party.
Private party.
Private party.
Yes. Owner of the building.
Then who appears for the
R7 municipality we appeal.
National Highway Authority?
National.
So the National Highway Authority will have the jurisdiction to deal with this subject.
It's a district highway, my lord. Now it is.
It's within city limits, sir. Limits are national highway. NH4. Bypass declared.
Oh.
Bombay.
Building constructed in 1985.
Right.
My lord, the government itself, my lord, occupied the building for, my lord, 15 years. Thereafter, they constructed their own building and shifted. This so-called encroachment is a bogey, my lord.
Let's seek a short accommodation. It's personal inconvenience, my lord. Senior is unable to appear.
Since the time was asked for on the ground that the senior counsel has been appearing, conduct the matter, has some personal inconvenience, stand out to 11th March.
Still number 23.
Right. Here for the petitioner. There is a suo motu PIL not registered by this court with respect to custody and guidelines relating to, my lord, custody of minor children and especially their psychological aspects relating to that. I filed a report, my lord, as amicus in this matter. And thereafter, there was also one intervention by a third party. And that your lordship also allowed and allowed them to be implemented as respondent number 3. I think they've also filed their submissions. Now it's really to evolve certain guidelines, my lord, with respect to having child psychologists to assist in the process of custody. And that is one part of it. And therefore, my lord, we have placed before your lordship 2 or 3 reports. Some reports which have been adopted by various high courts as being some kind of a standard by which courts can, my lord, decide custody issues, especially when there is parental alienation.
So today there is no guidelines for child custody.
Of
No,
course,
my lord.
guidelines are evolved only by courts to taking into consideration the best interest of the child. But that, my lord, is a concept which changes from court to court. And therefore, my lord, the High Court of Bombay and Madhya Pradesh have adopted a guideline which, my lord, has been brought into existence by a foundation called Child Rights Foundation. My lord kindly comes to page 114 of my report. This seems to be a fairly exhaustive one. There is also, my lord, a report by the Law Commission as well, suggesting various changes to be made. Some high courts have adopted those, saying at least apply those principles till the law is altered. Then Union of India said they are also coming out with some more guidelines. Of course, that never came before your lordships till now. But at page 114, my lord, has, I think, fairly comprehensive guidelines, which is something which can be utilized until there is a law or a change in the law with respect to how the best interests of the child are duly protected.
Exact prayer you are making.
No, the prayer is, if my lord kindly,
This you want.
in terms of an order passed by your lordships, if my lord kindly comes to the order, my lord, which is at page 11 of the writ petition.
So who are you?
Let's say appear for respondent one,
Union
Union
of
of
India.
India, my lords.
Number one,
Let's-
number one is?
Union of
Union
India.
of India, my lords, Ministry of Women and Child Development. That's one updation I require to give to this honorable court.
You are, what's your good name?
Sadhana is Desai, my lords. My lords, ASG appears in the matter.
And who is for state? You are for, madam.
And for respondent number three.
Who is number three? There is no number three.
My lord, the petition has not been amended. However, in September 2024.
Lordships are allowed that application. I think we have not amended that petition by adding the name of the respondent number 3.
I'm an NGO, my lord. I'm assailing along with the petitioner.
You are an NGO.
Please, my lord.
What is the name of the NGO?
It's Ayushman Initiative for Child Rights.
So everybody has filed the responses?
No, my lord, it's not yet. Minor suggestions, though.
Whatever, in the nature of obvious suggestions.
Just additional suggestions, are very minor suggestions, my lord, if I can pass it across the bench. Let's, I require 2 months' time to place my, my lords, suggestions on record. That is because, my lords, the guidelines are now in the pipeline. The challenge is, my lords, the government has to call for all the opinions from all the state governments and the union territories, which is, my lords, is consuming time. So they require another 2 months to positively come up with the guidelines, my lords.
The draft guidelines are ready?
They are, my lords, they are ready, but we are yet to seek opinions from all the state governments because it's central ministry. My lord, if I may make a
Until then, my lord, I think.
My lord, if, because the union, they've been asking for time, my lord, because they have to take instructions from all the states. if this matter could be referred to the rulemaking committee, at least for logistic purposes, time and again, the matter could, they could take it up, they could take up the matter and take instructions from the union or the state, my lord.
Refer to which committee?
Rulemaking committee, rules committee
Of,
of the High Court if
My lords, there is actually provision under guardians and
can we make it? Because rulemaking committee is no role.
no.
There's one provision under which the High Court can make rules so far as the Guardian and Wards Act is concerned. But not, which is why the.
We are the committee. You are the members.
please, my lord.
May I make one suggestion, Lord, your Lordship may consider this.
High Court rule committee has no role. We are the committee, you are the member.
Only for logistic purposes. That's-
So, in lighter way, but by the time the so what we propose is that all of you give your stand and suggestions and submissions in a tabulated form with some, if there are the studies are there,
Yes, I filed them.
comparative details.
Yes.
By the time the guidelines of the Union of India is available.
Please.
Then at an appropriate time, we'll proceed and dispose of it. In the
Right.
meantime, you give the synopsis or notes or whatever,
It's done.
based on the pleadings.
So far as we are concerned, Lord, I filed a small report with the guidelines and the plan, Lord, which can be followed in so far as child custody issues are concerned.
Have you filed something?
No, my lords, not
Union
yet.
has not filed anything.
Think something that we are underway to,
Oh, my lords, no, my lords, but
My lord,
my
I'll
submission
file,
can be
uh,
taken on record.
at least you file some reply that such and such authority is considering the framework
Please.
of guidelines.
Please, my lords, I
How
will.
much time it will take?
It's another 2 weeks' time, my lords.
File that much.
Please, I will, my lords.
my lord, I've also
Learned,
placed on record, because similar matter has been taken up before the Calcutta High Court as well. Those documentations also have been produced along with my recommendations.
You produce.
I've produced it, my lord. It's there in my intervener application also, and it's there in the additional documents also. And at Annexure R1. Annexure R1 is basically reference of the matter for the purpose of just getting the guidelines in order to the rules committee over there, my lord. And subsequently, my lord, is the response which is in R2 at page number 12. And my recommendations are already there in my intervening application, which has been produced, my lords.
This petition is a due motu public interest proceedings initiated by this court, which relates to framing of appropriate guidelines in child custody cases. The prayer is to direct the respondents, who are the Union of India and State of Karnataka, to frame the guidelines and effectively implement the same. Respondent 3, dash so and so Pura now, which is a non-governmental organization, is also arrayed as a party respondent. Full stop. Learned senior advocate Vidyan Chinnappa Your amicus,
Amicus.
learned amicus curiae. Apprised the court today about the subject matter and the ambit thereof to be examined by the court. Thereof. When the court asked as to whether any of the respondents have framed guidelines on the subject, learned advocate Ms. Sadhana, appearing for respondent number 1, Union of India, stated that the Union of India is already seized with the task
Please.
of framing guideline on the very subject, and that the views of the state governments,
State.
views
No,
of the state governments
Please, my lord, say state and
are-
union territories.
are being solicited.
Waited.
It was stated by her that within 2 months, 2 to 3 months,
Please.
the guidelines are likely to be finalized. Full stop. However, since this stand of the respondent Union of India is not on record by affidavit, it is directed that the Union of India shall file its affidavit stating the above facts and the timeline which may it require in finalizing the guideline, as well as the process which will be undertaken in that regard. For this purpose, stand over to enable the Union of India to file such affidavit, stand over to 19th March.
Please, my lord.
19th March. In the meantime, not in the meantime, learned advocate Ms. so-and-so files, what is this memo?
Additional suggestions to the report of
Additional,
the.
additional suggestions to the report of the amicus curiae in respect of the guidelines for child custody disputes. The same is taken on record. Full stop. It is further provided that the parties shall furnish their synopsis oblique notes oblique comparative or figurative chart on the subject and send us a copy to enable the court to streamline the facts to proceed further. Full stop. Such synopsis oblique details shall be filed before the next date.
Sir, my pleading point. My pleading application, I applied for the
Your pleading application.
ICJ and the UN Charter
We'll hear you.
about the child custody issue, sir. This is the medical perspective I bring in. I put it on your table 1 year back.
Learned, your party or?
Party
implicated
in
or
person, not who's
Yeah,
third
but-
party.
Impleted? Pending. Pending consideration of the impleading application, which is IA number 1 of 24, the party in person, what is your good name? What's your name?
Dr. Kamla Mukhanag.
Dr. Kamla Nag is also permitted. So pending the consideration and grant of the IA number 1 of 24, the applicant party in person, Dr. Kamla Nag is also permitted to submit her suggestions, views and inputs in relation to subject matter, correct? You file your.
But the third party, my lord,
By.
there is something already filed, my lord, but the
By. So madam, you assist Mr. Chinnappa, you assist them, you submit by submitting the necessary details to learned.
No. because what that, my lord, I can't really undertake that exercise. Really, Lord, is why I'm saying this. She wants, my lord, the matter to be referred to the International Court of Justice. And I don't know how I can stand here and ask your lordship to do that. Therefore, let her take care of it herself, my lord.
Sense of the writ petition is with respect to formation of guidelines for child custody, wherein the memo of documents that has been filed by doctor is for some other prayer itself completely. It is not related anywhere to the writ petition prayer, my lord.
Sir, my question is about the child. Children are victims. I'm standing for children, not for the other people.
Your perception is global, our is local.
It is the medical issue and it is the law issue.
You give something in writing, we'll consider.
Sir, everything I have submitted.
Submitted.
I submitted to her also.
Very good.
And it has gone to the central ministry.
Very good. Then very good.
What else?
Nothing.
So you please forward the issue to the Prime Minister, UN member state nation. So they forward it to UN chief. They appoint the legal scholar as scholars and they will crack the UN charter because the deadlocks are in the ICJ and UN charter and nobody has a jurisdiction for it. If we cannot talk about it, how we can solve the problem? So who has the jurisdiction to talk about the UN charter? ICJ. But we are going round and round in the child custody, the guideline, 150 years we have been trying. Are we able to help the children? Just-
We'll discuss the issue here and fresh out. Instead of going to Hague.
Sir.
Hague.
Sir, everybody says it is not there within the guideline. If I go to the Supreme Court, they say it is not.
We
within
don't
the
have
guideline.
means to go to Hague.
Sir?
We don't have the means to go to Hague.
No, sir. But you are a link. The problem is the non-judicial administration of highest constitution, sir. The chief and
we'll-
UN member state nation, they do not have jurisdiction.
Your standpoint will consider at the time of, you can give in the meantime to the court. Even if you have given to the parties, your suggestion you give to us,
Okay, sir.
right?
May I make one submission?
Kind leave. Serial number 28 and 29, Lord. It pertains to a batch of matter wherein your lordship was pleased to grant interim order. I am pressing for interim order. And so far as serial number 27 and 56 are concerned, there is interim order till the next date of hearing.
7.5 lakhs.
27 and 56.
7.5 lakhs.
Yes, Lord, same, similar. That may be, Lord, tagged with serial number 97, batch matter, Lord. And the interim order may be made absolute, Lord, because in the connected matter, it is made absolute.
So 27 is new matter.
No, Lord. It is already, interim order has been granted till next date of hearing, 27 and 56.
So they are new old matters, their interim order is granted.
Yes.
To be clubbed with serial number 97.
97. And so far as 28 and 29 are concerned, I am pressing for interim order. It is a similar matter.
Yes, my lord, 7.5 lakhs.
7.5 lakh.
All right. So which order will apply? Original order is 27.
Yes, Lord. I'm produced.
If you are able to.
Yes,
to
my
state
lord,
it
it's
that-
dated
it-
13th
it
November
was stated by learned
2024.
advocate Mr. S.S. Mahendra that this writ petition and the subject matter thereof is similar and identical to, similar to writ petition number 30419 of 2024, in which on condition of deposit of 7.5 lakhs, the court has granted interim relief while issuing notice. In that view, not in that view, learned additional government advocate Srimati Nilofer Akbar was not in position to dispute the effectum of the similarity of the petition and the order passed. Full stop. In that view, having regard to the order passed in writ petition number 32357 of 2024. No. D0419 of 2024 and writ petition number 32357 of 2024. There shall be notice in this petition as well. Then this paragraph, since it is the contents. Within
2 weeks.
within 2 weeks, yeah.
Not,
Amount to be developed within, so same order in 28 and 29.
That's serial number
28 and
my lords.
29, and so far as 27 and 56 are concerned, my lord, interim order has been granted till today. It may be May.
Stand out to which date?
My lord, they are all posted today.
Today, my
But
lord.
yes.
97 is also there, batch matter.
You want time? You want time?
They have to file response.
Let it be called up if it is,
That's serial number 90.
but you have filed some reply.
My lord, I have prevailed on the government, my lord, to take a decision in that matter. So I'll need some time, my lord, to
And-
get a response from the government.
In the facts of the case and at the request of learned assistant government pleader Srimati Nilofer Akbar, stand out to 28th of March.
Obliged.
Obliged.
And all this matter may be tagged together.
Interim leave granted earlier shall continue to operate.
Serial number.
Children are required.
So this will be, this will be order in 27 and 56. What about 97?
My lord, they are batch. my lord.
97, Lord, in that matter, I filed IAS for dispensation of, there is office objection only. In all those matters, interim order has been granted.
So 97 shall go to 28.
Lord,
yes.
even 93 also,
96.
even 93 also.
93 also.
Yes,
93 also stand out to 28.
obliged.
Sorry, 112 whether.
Document will be issued, he will become infectious. Leave may be taken up tomorrow.
Infectious, Monday.
Plus 112 where the children are
You will
required to
issue
be
tomorrow,
present.
the submission is, if you will issue tomorrow, the appeal will become infectious, that's why. I kindly pray for tomorrow,
So what appeal you want to list?
tomorrow.
No, memos are not accepted at 11.
112 where the children are.
No,
required.
no other time in the day of the, during the day, memo will be accepted, except 11, yes.
112 where the children are required to be present at 2:30. They have filed an affidavit in the contempt petition complainant saying that the children should not be subjected to such an exercise. And because of my insistence, the children are called. The matter can be taken up, but however, whatever
Matter,
your
it is
lordship
at
suggests,
2:30.
I'm okay.
It is at
Children should
2:30.
not be called by the court.
Yes, they have
It
filed an
is-
affidavit
they
saying
have-
that
no, they
because
have-
of my insistence, the children are called and they should not be subjected to
lordship,
such an
consider.
exercise.
We'll consider at 2:30.
2:30. They
No,
have
I-
violated the orders.
I'm not able to, I don't know whether I should bring the children from the school or because they're saying it should not be subjected to such an exercise and it's my insistence that I'm
No,
subjected.
they-
Need not,
have both.
need
Them.
not, need not bring.
Great,
for the
my
time
lords.
being.
Serial
Because
number
they have filed an
9.
affidavit to that extent.
96, my lords, the service is
2:30
completed
that
so far as
matter
the
is.
respondents are concerned. Matter may be.
That matter is at 2:30, it may be taken.
Yes, it may be taken, but if your lordships feel that is a
96 services complete insofar as response are concerned. Matter may be listed for admission on, matter may be listed on admission any day, my lords. Serial number 96, services complete insofar as response are concerned.
So what do you want?
It may be listed for admission on any particular day, but my request.
Give some date after 17th March.
Kind.
Serial number 26.
Seal number 1, the review petition 609 of 2024, Mr. Shrikant MP, to Shanti Bhush.
Wait for the response.
Review petition is dismissed. In view of dismissal of review petition, the inter-record application seeking condonation of delay and production of additional documents would not survive for their consideration. Accordingly, applications are rejected.
Great.
Seal number 2, the AT Malya.
Right, delay in filing the appeal petition. About 3 days, effectively 1 day, because 2 court holidays intervened.
Yeah, delay.
I filed it on 31st day. There is a delay of effectively 1 day in filing.
But everybody is appearing.
Respondent number 1 to 3, my lord, and 7.
So 4 and 5, 4 to 6,
Private respondents.
they are served.
Served, it's served,
Served.
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 My lord,
Not. Not served.
Personally served.
served on the council. It's
Memo has been also filed.
During the council, the parties are served. Not through council.
Council,
Not through council. You serve. We additionally permit you to serve through council, but parties have to be served. Serve it. It's You have not collected help himself.
no, a copy of it has been served on the other side, and we have filed the memo also to court.
But you have served to the council,
Council.
not to party. So wherever the parties are not served, they shall be served before the next date. So we'll list it after 10 days or so.
Yes. Seal number 3.
Yes, madam. Post.
I have filed the memo, my lords. This is extra copies, my lords. I have filed it in the counter, my lords, morning. It's not put up, my lords. My lords, it was with regard to non-compliance, my lords, non-payment of cost of rupees 5 lakhs, my lords. I had paid it, my lords, in the month of October. We could not file the receipt, my lords. That's it.
Memo dated 27 to 25, tendered today and taken on record, suggests that the cost of rupees 5 lakhs imposed as per order dated 23/9/24 while disposing of the writ petition has been paid by the petition.
Please.
In that view, nothing survives. No further order, in that view, no further orders are required.
Please, my lords. My lords, the direction was given to respondent university to approve the admission, my lords, but it is not yet approved, your lord.
Contempt.
Please.
Seal number 4, to Mohammed Shamir.
My lord, I appear on behalf of the appellant and applicant in this matter. The respondent company continues to remain in CIRP. However, the withdrawal is underway, requesting for a short adjournment, my lord.
Adjourn at the request of learned advocate, Miss.
Neha,
Give the name, yes. Who- It is
Lordship on submission. See, as far as serial number 19 is concerned, the cost may be reduced by lordship because petitioner is not able to afford that much cost.
All right, we'll reduce to what extent?
Maximum, Lord. Maximum, if I may repeat on this behalf. Maximum.
So tell us, cost will have to be, because this totally,
Apologizes, my lordship.
you may not be part of that guilt, but your client certainly.
For 5,000.
10,000.
Much of.
The lordship's kind permission.
I don't know whose request we are accepting.
But we are accepting.
Incidentally, I came to mention that the youngster was there. Sometimes it becomes.
Very
difficult for us.
Yes.
But one matter.
Which one?
Number
110.
110. The period of the term of the Sangha expired, Samjiga Sangha. Expired in 2021. Why the rate? Because during its subsistence, we had filed applications to enroll as members. And purposely, they wanted to create a coterie of their own family members. They only had enrolled their own people. Purposely, they avoided. We find the rate. There was a stay during the pendency.
Calendar of events issued.
Directly not to hold.
Calendar of events issued.
Now it appears in the justice. Matter is there before your lordship, section number 110. Anytime they may issue the calendar of events. They have been issued. Fairly admit members. Admit as many members who are.
Member says?
For the institution, Malajiga Sangha. Those persons belonging to that caste only.
So you want to take it up?
Please do not take membership, yes.
No, you want to take up the matter?
Yes, but matter to be.
Next week?
One issue, my lord, is.
My lord.
Government, the single judge has directed the government registrar to appoint a returning officer to issue calendar of events. If they are instructed, they are directed not to precipitate them. That is, we can, the matter to be heard. Till then, because before single judge, interim order was operated, not to hold election.
So next week we'll take it.
Because if he
No,
issues
the calendar of events, my instructions, my lord.
We may not get time, that's.
I can make one submission, my lord. The calendar of events, my instructions are that it has been issued, my lord, already.
Judge had directed the government, the registrar to appoint returning officer to issue. Returning officer is appointed, but returning officer has not issued the calendar.
Returning officer only.
Returning
Headline, head note.
Returning officer has not issued.
Yes.
Monday.
Very well.
Monday 2:30.
It can be connected.
Yes. 2:30. And connected matter is also there. Otherwise, it becomes infectious. Monday 2:30.
Lords, I'll accept notice on behalf of respondent. Matter is going to be heard. Lords, I'll accept notice, my lords. I'll accept notice, my lords, on behalf of respondent.
Let them not precipitate till then. If at all, if they are not issued.
Issued. My lord, the instructions are that it has already been issued, my lord, so it may be taken up on Monday.
On Monday too.
Very well, my lord. Very well. And may I make one addition to lordship, my lord? Number 47 matter pertaining to transfer. For the last 1 week, 6 months, he has no salary. My lord posted the last week at 2:30, my lord, day before yesterday, it was came other bench, posted today. May I seek an, lord, Indian said 5th March at 2:30. 5th March, 5/3, or at 2:30, my lord.
No, 5/3 will keep, not at 2:30. We'll just, if it doesn't read, then remind us.
5/3.
5/3.
Bill number 15. The contempt 549 of 2024.
For the complainant, my lords.
contempt petition is dismissed.
Bill number 118, writ petition 5526 of 2020.
Recording the submission of the state, the writ petition is disposed of with a direction to the respondents to preserve and maintain the parks, play fields, and open spaces in accordance with law.
Obliged.
Remember? Mention ಮಾಡಿ sir.
119, it's for withdrawal, my lords. I seek to withdraw 119, my lords. It's listed at 230. Filed a memo to that effect. It may be dismissed as withdrawal.
119.
Please, my lords.
Blind. Writ appeal number 90 of 25.
Please, my lords.
Figures on record, memo dated
22 to 2025.
22 to 17 to 2025, filed by learned appellant Mr. Srivastava Rao, in which, for the reasons stated in the memo, he seeks permission on behalf of the petitioner to appellant to withdraw the appeal. Permission is granted, the appeal is dismissed to withdraw.
Obliged, my lords.
This 230 matters, serum 112. Mr. ABS Manian.
What's in this?
Last hearing, your lordship had, by order dated 22/2025, your lordship had directed the parties to appear. And my lords, after your lordship's order, once again, they have breached the order dated 12/7/2024.
Look, they filed an affidavit. May I just urge your lordships to turn to page 11, my lords, wherein my email has been also attached by them. It's document 2, page 11. Your lordships got it, my lords? The recent affidavit, my lords, that they have filed, I'm not sure of the date, they have not mentioned the date, my lords. Plus, though the email was sent at 6:55, there was no response. And in fact, they have stated that he has filed an affidavit stating that his counsel informed him only on the next date about my email. So I have offered. That's even the affidavit makes an allegation that it is on my insistence that the court wants to interact with the child, and it is not necessary at every para, my lords. Para 15, may I, my lords? Bringing my minor son and daughter to the honorable court after tutoring, traumatizing, blackmailing them.
is not in the best interest, exposing him at this tender age to an open court environment and witnessing their parents in conflict in public will create lifelong scars in their young minds. And para 11, they state that respondent's counsel emailed my counsel at 6:55 stating the children had a party and refused to go. The email suggested a pickup at 8 p.m. And my email clearly says that they can be dropped next day. However, there has been no response to the email at all.
Lords, if there was a party, they should have told the previous day that there's a party the next day, please come at 8 o'clock. Lords, most importantly, the children are just 5 years and 3 years old. Party till 8 o'clock is quite unimaginable. Lords, finally, the children are affected. The children are so fond of the grandparents, so fond of the father. The father has just come out of a brain tumor surgery. And for him, his only solace is his 2 children. Unfortunately, my lords, the parent is not taking the interest of the children in mind. And I've come to this court.
But the earlier weekend, the children did spend with the father.
The earlier weekend, the children spent with the father. It went off very well. It has been recorded by your lordships in the order dated 22. This is nothing but an after effect of that. My lords, the order has to be respected. Your lordship, my lords, is exercising jurisdiction under the parent patriarch and contempt jurisdiction. If my learned friend is not following the order, my lords, we don't want punishment. Let the custody of the child be given to us. We'll give her 24/7 access to the child, which will be in the best interest of the child. The children, my lords, need both the parents. Joint parenting is the rule of the day today. All courts, my lords, ensure that that is done. If she is not able to ensure that, we will ensure that, my lords. We don't want to restrict her from the children. We will give her 24/7 access. If she doesn't, this order was challenged before the Honorable Supreme Court and the SLP was dismissed. And we have filed it before your lordships. And this was not disclosed to your lordships.
Plus para 11, they state, sending an email at 6:55 on a Saturday night outside regular hours further suggests questionable and malified intent.
The short point is to implement the order of 12/7.
Do you want to go for
Plus,
mediation?
I did.
My lords,
Do you want to go for mediation?
my lords, when she is
think that would
blatantly
be-
violating the court order, we are not sure where it will lead to.
Because I think there has been.
Because of your lordship's blessings and interference, the children came to our house on 15th and
Don't give
16th.
less. First of all, we don't give blessings to anybody. So, be precise in your submission. We don't give blessings to anybody. Phraseology and submission of the kind in the court of law is not warranted. So we are asking whether you are going to opt for mediation.
Since mediation has not happened in this case, I would definitely urge for the parties to go for mediation and work out what are the modalities, and I think it can definitely be worked out, my lords, is my
Coming
suggestion.
from outside?
My lords, I come from outside.
So that is not the language of the High Court of Karnataka,
I'm sorry, my lords.
and never was the High Court of Gujarat. That you seek blessings from the judges. Please don't use such words. Yes,
Yes, my lords, I'm sorry. my
I'm
lords.
very touchy about your submission, the language of submissions. And what kind of awareness you are making in your affidavit today?
My lords, as it's a custody issue, the tempers are high, my lords, emotions are high.
No,
I'm
no,
sorry,
our tempers are not high.
My lords, the parties.
Parties
I'm
tempers.
very sorry.
So tempers are high and that is reflected in paragraph.
Yes,
Mr. Counsel, don't be smart
yes.
and don't cast any aspersion, whatever comment we made, in whatever tone we made.
My lords,
It is not the tempers.
of the parties, my lords, I'm sorry, of the parties.
We understand what you are trying to judge, Mr. Counsel.
Yes,
So what kind of awareness you are making in your affidavit? Look at the page. Any breach of discipline, I will never, discipline in language, I will never tolerate. Yes. What is paragraph 7 in your affidavit? What are you saying? Why you are making such awareness? They are not preventing. Who says that reference is made to only unjustified
even
demand by
earlier,
the respondents' counsel
such
that
kinds have been.
parents, grandparents, children with them, deeply attached, be kept out of proposed interaction with the court.
Yes, even earlier they have made this, my lords. Everywhere they have made the same
We have
thing.
not said so anything.
And when
We
it
only
comes,
said in our order that the parties have agreed to keep the clients, respective parties along with the children present before the court on 27 to 25.
absolutely.
And what you mentioned was also not right, madam.
My lords, I'm sorry, my lords.
And in the
Afternoon,
three lines-
I'm sorry, my lords. It's because they have been making allegations against me, and I do not want to come across as somebody who's subjecting the children to.
suggest that
I'm
they are not-
extremely sorry. Yes, I do understand, my lords. I do understand. I'm extremely
suggest
sorry.
That they are against bringing the.
They are writing here, my lords. Even at para 12, they say in the current.
That is not the tenor. They are saying that you are trying to prevent the interaction.
No, my lords, at para 12, they say it is not conducive to have any interaction with the respondent or for this court to have an interaction with the children. Plus para 12,
Try to go for mediation. How to take instruction.
plus one mediation, I think is.
Frankly, very frankly speaking, notwithstanding the orders, if either of the side, kindly listen. Kindly listen. Very frankly speaking, notwithstanding our order and notwithstanding your agreement recorded in the order that they will bring the child here for interaction along with the parents. Any shade of reservation, unwillingness, disinclination to bring the child before the court, we are not interested.
Because I've always
Then
been ready and willing.
it is only our moral and legal duty to forge some alliance
Absolutely, my lords.
and affection to solve the issue that we are interacting.
Absolutely, my lords. I'm
They are
grateful.
otherwise not interested.
In fact, I'm grateful for the
They are not
indulgence
interested
of
in the
this court.
process and the resolution, we are not interested. So kindly make it clear whether you want the order to be implemented. Otherwise, we'll argue, please argue the matter, we'll take it to logical.
Plus, I'll file an I'll file a reply stating that it can be complied. There is no difficulties. However, sometimes when the child has some like birthday parties or something, the child will want to go late. That should not be an issue.
As counsel is rightly saying, in a different way, though in a different expression, everything court go on recording everything in matrimonial matters, and these matters, custody matter will not be proper. Many things go without black and white, out of understanding, out of the nature of the matter, human relationships. So what do you propose you tell us on the next step?
If they are agreeable for mediation, I would definitely, my lords, I would pray your lordships to refer this for mediation because it has not gone at all, even for once. So I would say the parties can work out something before the mediator, a skilled mediator, my lords.
The children are mingling with the father very well.
My lords,
The children
Well, the
are very
parties
well,
are here.
very well mingling with the father, as the photograph suggested.
yes, no difficulty. He will be sent, my lords. That apart from that, if mediation can be attempted at by the parties, I think it can resolve all the issues between them because there are several petitions pending between the parties. So one mediation, I think the parties.
See, the photographs reveal that the kids too love their father.
Definitely, my lords. Yes.
But in this affidavit, of
No,
course,
it was
filed by
only-
them.
Yes, my lords.
Of course, filed by them. If the boy shouts from the balcony, I don't want to come, you go away.
He's not shouted like that. My lords, what has happened?
If that is true, it only indicates that his mind has been poisoned.
No, my lords. He is told that I'll be coming late. They didn't wait for
In
him.
the interest of your own children,
Absolutely.
You are advised not to poison the mind of the children
Not at all. Yes, my lord.
against both the parents. It's
True.
very essential. It's very essential.
Plus, he did not shout like that also. In fact, they have stated that. He only said, I'll be coming late, which they did not wait. They went away. And unfortunately, they did not even come to pick up the children at 8 o'clock. In the email, my lords, it suggested that they can keep them overnight, in fact, keep the elder one as ordered overnight. That is not done. Plus, that compliance, I've already advised my party. That should not be difficulty, my lords. But apart from this, if this can be referred for mediation, I think a lot of
And
matters could
you
be
should not
sorted.
be casting aspersions on the council for
Absolutely, absolutely,
response.
absolutely, absolutely. This was,
This is not
Yes, ma'am.
what
Yes.
is expected.
yes, ma'am.
No, that's improper.
Yes, ma'am. Yes, ma'am.
Plus, any date that your lordship,
That's right, but what is in the meantime?
Milords, may I suggest this, Milords? What fell from the lordships? Milords, lordship may have this matter after 2 weeks. Let them comply with the order for the next 2 weeks. Then we will get back on mediation, which will be a positive. Let them comply with the order.
I only suggested parallelly it can go,
Which
but
one?
it's all right.
Milords,
I have no issue.
2 weeks
Order
from
to
now,
comply.
Milords.
Visitation,
Milords, the same order.
visitation,
Yeah, Milords,
visitation rights.
Yes.
Correct.
the same order, 12-7 order.
12-7. Where is that order?
Plus,
The order
12-7 is
page
at
number 20,
26.
26, Milords.
Correct. Learners in same,
Yes, same.
which is under subject.
Next 2 weekends, let them comply with that order. I will convince my clients to go for mediation.
Very well.
All right.
It is in the background of, right down. It is in the background of order dated 28. It is in the background of the observations made in order dated 28 to 25, I recall. The contempt petition comes up again. Full stop. Figures on record. The affidavits. Filed by petitioner father. Dealing with the events and happenings occurred during visitation of the child to the place of father on 15 to 25 and 16 to 25. In the detailed affidavit, it is claimed that the children were at ease with the father and the grandparents, and they spent joyful time with them. Post of the affidavit accompanies the photographs capturing the moments as well as the pen drive. Full stop. A further affidavit dated 25, not a further affidavit dated 25 to 25. Has been filed, in which the visitation dated 22 to 25 and 23 to 25 is detailed, and various factual aspects are mentioned. It is to be recorded that the court disapproves the averments made in paragraph 7 of said affidavit dated 25/2/25. Paragraph. Furthermore, though it was recorded in order dated 28/2/25 in paragraph 7 thereof that the learned advocates that the learned advocate parties had agreed to keep the parties and the children present before the court on 27/2/25, for the reasons transpired and submitted, the court permitted respondent not to permitted the respondent, court exempted the respondent from bringing the children. The interaction, the aspect of interaction with the children may be explored if required on the future dates. Full stop. Learned advocate, Ms. So and so for the respondent wants time to file affidavit.
Reply to the.
In response to the petitioner's affidavit. The time is granted. Stand over to of 2 weeks.
2 weeks, my lords.
17th March.
In the meanwhile, let them comply.
Full stop.
There is no difficulty. In fact, we have been sending. It was just last because of the birthday party. A few hours was just.
It is provided that in the meantime, the directions of learned single judge regarding exercise of visitation right by the father shall be continued to be complied with by the respondent, and the children shall be permitted to be visited as directed at the place of father.
Yes. Order dated 12/7/2020.
Plus, may I request?
The order dated 12/7/2020.
As per order dated, as per the directions and order dated, yes, 12/7/2024 passed by learned single judge.
But instead of 17th, may I request on 21st, my lords? Is that all?
21st.
That's all right. Great.
21st of
March, my lords.
March.
But sorry for the language in the affidavit as well as.
Doesn't matter, we don't remind us. I speak but never remember, that's all.
Much of it.
So.
Grateful.
Because the petitioner's presence may be required.
Looking to the.
Parties are present. That's compliance
It
with
was
the lordship's
stated
order.
by learned advocate petitioner, Mr. So-and-so, senior advocate petitioner, so-and-so, the parties are present.
Yes,
The
petitioners are present.
presence are taken note of. Full stop. Looking to the nature of the dispute involved, where the stakes of the future of the minor children are involved. And to ensure that the future and well-being of the children are not put at the altar of the altercations between the dispute between the parties, let both the sides take instructions about thing for mediation process to resolve the issues.
Much obliged.
Grateful.
Blessings is Madras High Court language. Because your lordship is Lord, we say blessings. Much obliged.
It goes on in the courtroom, don't take it.
Yes, my lord. Much obliged.
Number 113, Mr. Manjunath KV.
Yes. 113 for withdrawal. Pardon? Filing some affidavit.
Worship, may kindly see para 10 and 11 of the complaint.
What happened? You done it?
Please, committees have been constituted, my lords. Across the state, my lords, 169 committees has been constituted, my lords, which is as per Measure R2, my lords. And grievance of the complaint has also been considered by issuing an endorsement, my lord, saying that the land in question will fall within the limits of the municipal corporation is my things, my lords. It's also covered by the judgment of this lordships, my lords. Of your lordship's judgments, my lord.
My lord, if I may, my lord. My lord, the order says you have to form the committee, my lord. Yeah, and the distance has to be considered on the date of application, my lord, not as on date, my lord. My lord, adjoining land, my lord, very same Tahsildar has given up endorsement, my lord, saying that it is 28 kilometers up on 2011. My name, my lord.
So now,
But it's two different things, my lord. Date of application is when they have to take the distance, my lord, not as on today. What this honorable court has said, my lord, and that is a law, man. My lord, the distance has to be calculated on the date of my application, my lord.
Yeah, what is this? This is
no way connected, my lord.
This is, my lords, where the
some earlier bit.
please, my lord, to say that his application was ineligible to be considered.
No, my lord, but the order is to form the committees, my lord. That is not what they have done, my lord.
But then committees are formed, then
Yes, my lord.
your applications are considered.
No, no committee is formed. That is not done, my lord. They are not complied with that.
They're saying that.
No, my lord, deputy commissioner has considered, somebody has been delegated,
No, what is
not the
this?
committee, my lord.
I submit that as per order of this court in so and so and so. Total 11 committees have been constituted in 14 constituents.
Please, my lords.
Which
Not
are
in
as
this- Not in our place, my lord. Somewhere else they have done.
In this place, my lord,
This is just clever drafting, my lord, not here, my lord. Somewhere else they have done.
my
Not
submission,
our place, my lord. Let them say it is done in our place, not done, my lord.
may I submit, my lords? In this case, my lords, where the present application of the complainant, my lords, falls within the limits of the municipal corporation, my lords, where is bars under the Act of 94A, my lords, that cannot be constituted. There is a bar under the Act, my lord, that there's no requirement for formation of a committee, my lords. Your lordship may kindly see your lordship's order. Wherever necessary committee is to be created before, is to be formed, my lords. That is the order of the, your lordship may kindly see for a moment, my lords.
No, Bangalore North is not done, my lord. We have given 11 committees, my lord, and the places, my lord, none of them, we are in Bangalore North, my lord. not-
Page number 54 of the content petition, my lords. The operation part may permit me to read, my lords. May I read, my lords? The Principal Secretary Revenue Department is directed to take necessary steps to have the necessary committees constituted in the state on or before 15/12/2023 for considering the application filed for the regularization of unauthorized occupation and cultivation. In this case, my lords, there is no necessity to form a committee, my lord, for the reason that, my lords, under section 94A, my lord, it bars, my lords, because the said land is falling under the within limits of the corporation of 18 kilometers, my lords. For such circumstances, the committee was not formed for this case, my lords. In rest of the state, my lords, 169 committees have been formed, my
then
lord.
committee is to be so formed or directed to consider the applications filed
Please,
by
my
the
lords.
petitioner.
Please, thereafter, my lords, application has been considered. It is not before the screening committee because the deputy commissioner has considered the application rejected. That's the reason I have relied upon the judgment of your lordships, my lords. Page number paragraph number 2, my lords, where your lordships is observed in content petition 713 of 2024, my lords. Maybe,
That is factual because you are saying that he is not eligible.
please, that's the reason it was not placed before the committee, my lords. And committee, there's no necessity to form a committee because it is falling under the municipal limits of 18 kilometers, my lord. And there is a bar under section 94A of the Karnataka Municipal Corporation.
Right.
Not only for this, my lords,
What is 94A?
if any land, my lords, is falling within the city limits, my lords, cannot be regularized, my lords. There is a bar under the act, my lords.
Why you are not forming committee in respect of the district of the petition?
My lords, there is a bar under the act, my lord, to that cannot be considered, my lords. My submission is that, my lords, it is falling under the city municipal limits, my lords. That is what I have called out in my compliance affidavit, my lords, which are the places in the state is falling under the city municipal limits. That's the reason it has been screened by the deputy commissioner and not been placed before the. That is the reason I relied upon the judgments of the lordships, my lords. May permit me to read, my lords.
Of law relates to formation of committees. First, show the provision of law.
My lords, as per the directions of this honorable court, my lords, was directed to form a necessary committees, my lords.
Council,
Please, my lords.
regularization of unauthorized occupation and cultivation of land. How it has to be done. Show the provision of law. And also refer to para number 2 of the judgment,
Please,
where the government advocate appearing for respondents, that is the state, upon instruction submits that the government is in the process of constituting the committees, and immediately after constituting the committees, the matter will be considered and disposed of in accordance with law, including that of the petitioners. This was the undertaking given. Now you are saying that there is no requirement to constitute a committee, and who, Tahsildar or Deputy Commissioner, who has acted in this case?
Tahsildar, the endorsement is issued by the Tahsildar, my lords.
Tahsildar himself is at liberty to issue such an endorsement. Show me the provision of law.
Lordship, I kindly see, my lords.
Land reforms, land revenue.
Please. My lord, as per the Land Revenue Act 94A, my lords. Lordship, may kindly see paragraph number 4 of my affidavit, my lords.
Show the provision of law which says that a Tahsildar can reject it.
It's not rejected, my lords. Its application is kept pending, my lords. It's delayed alagide or is endorsed in the.
Now, what does it mean? Now only you said it falls within these many kilometers.
Please, my lords.
And because of which the endorsement has been issued by Tahsildar. Show us the provision of law which empowers the Tahsildar to do it.
May I read, my lords, 94A, my lords.
Section 94A pertains to constitution of the committee and the committee in turn deciding about the application filed by certain persons
Please.
who are in unauthorized occupation and cultivation of the land. Which provision of law enables the jurisdictional tahsildar to reject the application without placing it before the committee?
Please, my lords. To
Show that.
Please, my lord. To that effect, my lord, there's also a circular, my lord, government circular, my lords.
But Mr. All said and done in view of the direction of the court, what prevents you from forming a committee in respect of this district and decide the application of the petition?
My lord, since this, since
Why
the-
you are so confrontative with the court in a matter of ultimately a procedure or some steps to be taken to constitute a committee and decide the application on merits of the
my
application?
lords.
Why you are not doing that?
The only
In fact, even the examination of application on merit is also a function of the committee, not the tehsildar.
My lords, even before placing it before the committee, my lords, the deputy commissioner has a power to screen the application. That is, there is a circular to that effect, my lords. My lordship may kindly place it before your lordship consideration, my lords.
What is that?
Please. On 29/9/2020, my lords, there's a circular issued to the deputy assistant commissioner and Tashildar, my lords. To that effect, my lord, there's also a notification, my lords, that the amendment brought to Rule 108C, my lords. In the Karnataka Land Revenue Rules 1966, in Rule 108CC in sub-rule for the words and make recommendations to the committee within 3 months from the date of receipt of the document from the Tashildar. The word Tashildar shall forward eligible application to the Deputy Commissioner for further necessary actions, and the Deputy Commissioner shall reject the ineligible applications. The Tashildar shall thereafter make the recommendations to the committee or additional committee regarding eligible application within 3 months from the date of the receipt of the report shall be substituted. So in this case, my lords, his application was screened and was placed before the deputy commissioner and was found ineligible for the reason that the land is falling within the 80-kilometer limits of the municipal corporation. For the said reasons, my lords, his application not been considered, and for these under the bar, my lords, the committees have not been formed, my lords, since there is no requirement to form a committee. That is what your lordship has observed. Wherever necessary committees are required to be formed.
Go to give copy to of this.
Please, my lord. I had.
Madam, one more thing, my lord. This honorable court, my lord, the judgment is held like this, my lord. This is not been set aside anywhere.
Okay.
My lord. The very same distance, my lord, to be taken into consideration, my lord. Kindly go to para 12, my lord. What he's saying is against this order, my lord. The distance has to be calculated is what, how it has to be calculated is said in this order, my lord. Kindly see para 12 and 13, my lord. What he's saying is opposite of what is doing.
But how do we know that it is differently calculated?
My lord, it is on the date of the application, my lord. 91 was the application. He has now, what he is saying, as on today, it should be as on 91. And for that, my lord, adjoining two lands, my lord, the very same Tahsildar has given
on endorsement, my lord, saying it is 28 kilometers in 2011. If I may, my lord. Same village, my lord. No distance. My lord, in page 9, my lord, 8 is the Tahsildar's endorsement, my lord. Same village, my lord. As on 2011, he says, my lord, next page, my lord, 24.30 kilometers from the boundary of Bangalore City Corporation.
24.30.
Beyond the 18 kilometers that they claim now, my lord. And there's a report also, my lord. Same village. Should be considered as on the date of application, my lord, not as on date, my lord. And this has to be placed before the committee, my lord, and they have to say. Because the order of the Honorable High Court, my lord, which says that this is how it has to be calculated. And that has not been challenged, my lord. They follow the same thing everywhere, my lord.
This year amendment was, which
2020, my lord.
order is substitute.
In your amendment, you have said
Please, my lords.
only eligible applications will be placed before the committee.
Please, my lords.
See, it is not the discretion of the committee. Whims and fancies, it cannot decide that, yes, I will give it to A, I will reject it to B. That can't be the case. There are yardsticks prescribed in the statute which says what makes a person eligible for regularization of his unauthorized occupation and cultivation of land. Correct?
Please, please, my lords.
If he satisfies those parameters, he is eligible. If he doesn't satisfy those parameters, he is not eligible for it. It's as simple as that.
Please, my lords.
The committee is required to examine whether he is entitled for the land or not entitled for the land. If the Tahsildar himself examines it and he places it before DC and DC takes a decision whether he is eligible or not, if he is eligible, where is the question of placing the eligible things before the committee? You mean to say the committee has become a dummy, is it?
No, my lords.
Then what is the role of the committee?
My submission is that, my lords, the initial process, my lords, whether to find out the application is eligible or not is the first criteria.
No, you should say what constitutes eligibility.
Please, my lords. Now,
See, there is according to you, there is a role for Tahsildar
please, my lords.
or the deputy commissioner, as the case may be. In addition to it, there is another role for the committee. That you have to explain. See, we are unable to appreciate this distinction because for us, it's either a person who is making the application is eligible or not. That's all. He is eligible, he is entitled for the land. He is ineligible, he is not entitled for the land. The committee is constituted as per the statute, and your notification cannot overrule the statute.
Please, my lord.
A committee is constituted as per the statute to examine whether a person is entitled for grant of land as prayed for.
Please, my lords.
That is the purpose of the committee.
Please, my lords.
Now, you come up with a notification and say eligible things will be placed before the committee. That means to say they have to approve all the cases that is placed before them according to you.
In this case, that is not the case.
Not in this case, mister. What is the effect of this so-called amendment, what is the role of the committee then? If this amendment is given effective, you have to distinguish and say, what is the role of the Tahsildar? What is the deputy commissioner on one hand? And then the committee on the other. Now, according to you, they place the eligible applications before the committee. What the committee is required to do?
My submission, my lords, wherever the committee is required, my lords, it has been constituted, my lords. That is what I stated.
First of all, what is the role of the committee?
To look into the.
Then what is the role of the deputy commissioner?
Please, my lords.
Answer.
Whether the application is found eligible or not has to be considered is the first criteria, my lords, to be fulfilled.
Yes, it is found eligible. Then what happens?
Then it has to be placed before the committee, my lords.
Then what happens? Committee has to necessarily approve according to you.
Please, my lords.
It cannot reject.
True, my lords.
File an affidavit. Can you do that? This is the first time I am hearing this jurisprudence over here. You should be careful what you answer. Or there has to be furthermore clarification on these circumstances. The applications will be scrutinized and thrown out at the first instance, which is the job of the deputy commissioner. And thereafter, it will be placed before the committee, which will examine whether to grant the application or not.
That will certainly submit, my lords.
And when a direction is given, constitute the committee in consultation with your officers. You are required to constitute the committee, otherwise you are in contempt. What do you mean Bangalore does not require constitution of the committee? Even by present day standards, you don't have 18 kilometers beyond Bangalore, is it? Bangalore is an island covered by sea, is it? What? What should happen to those applications? You answered the same things on the last occasion. Today, except filing an affidavit, you are answering the same in the same manner. Why we should not haul up your officers for contempt?
That will certainly submit, my lords. The next state, my lords.
Last time also virtually submitted.
So what prevents you from forming a committee for this dispute? What is at stake? Any other serious stake
No.
in not forming the committee? So we are treating you in contempt in light of the directions in the earlier order. So the width of your contempt action is greater than what is in this particular matter.
If short accommodation is given, my lord, I'll explain, my lords. Certainly, and I'll explain, my lords.
No, we won't explain, we won't comply.
Please, we'll report about the same, my lords.
Explanation you gave last time, this time, we are not satisfied. Well, let we give one chance, then we'll take an action.
Short accommodation, my lords. Short accommodation may be given, my lords. I'll report compliance on this, my lords. Short accommodation may be given.
Short compliance, we will record it. At the request of while learned additional government advocate, Mr. Raghavendra was unable to convince the court about the stand of the respondents regarding non-commission of contempt. From it is request send over to 18th March.
Please.
It is observed that on that day, if proper explanation and oblique or stand is not does not forthcome, the court will take a serious view of the
Please.
Number 114, Vasant Kumar HT.
As per the order of this court dated 24/1, Lord, the accused had made the first payment of the installment of 5,30,000. But I am passing on the memo along with the extracts of this transparent with affidavit of compliance for making the payment of the first installment.
Today he make payment.
5,30,000 has been paid as per order dated 24/1, Lord, 25. Here, your lordship, Lord, has granted a request for making the payment of 10,30,000 in two installments. But for first installment, 5,30,000, time given, Lord, till today has been, Lord, promptly paid. I have filed affidavit also.
So, already this lordship has given direction to pay the entire arrears of maintenance on or before 21st March 2024. Till 1 year, my lord, he has dragged on the
Lordship
proceedings.
may kindly peruse the order dated 24/1/25. Para number 4 minutes. Learned advocate for submitted that the out of shared amount of 10,30,000, 30,000 is paid today itself to the complainant wife. It was requested that payment of the rest of 10 lakh respondent may be permitted to have two installments at the intervals of 4 each week each. In the facts of the case, request is granted. Petition shall come up with the next on 27/2 at 2:30 PM, on which date respondent shall report compliance about payment of first installment 5 lakhs. 5,30,000 paid.
Already paid.
Please, ma'am. Already paid. I have filed an affidavit to declaring that I have paid the amount. Affidavit is also enclosed.
Order on or before 28/3/2024.
5 lakhs I requested for another 4 weeks. Your lordship has also granted on the last occasion itself.
So this is the only contempt non-payment of.
Lord, 5 lakh, another 5 lakh, I will not make a payment.
Another 5 lakhs has to be paid.
I'll make a payment.
But he himself filed an affidavit.
That is the my lord, your lordship, my lord.
You have forgotten the original direction. Judgment and decree, pay the maintenance is confirmed, the arrears to be paid. So once this 5 lakh is paid, everything will be over.
Another 1 year is due because
that they can work out in the execution petition, my lord, let them not.
When you are proposing to pay the remaining arrears.
Lord, this, my lord, before this contempt column on 20th/8/2024, lordship is calculated amount of 16,60,000, which I have to pay in the contempt petition. That, my lord, to that effect, my lord, the order passed in the division bench, MFA dated 2/3/2/31 of 21 will be fully complied. For the remaining payment, they have already filed the execution petition. Execution petition is going on. This will be adjusted in the execution petition. Rest of the amount they can recover because a lifetime order of payment of permanent alimony 40,000 every month. Execution filed, simultaneously contempt petition is also filed.
But operative portion of the division bench order can be appreciated, Lord. The appellant here directed to deposit make payment of the arrears.
These are arrears. Are you paying regular 40,000?
Yes, regular 40,000. They filed a contempt for compliance of the
Let me submit it. But the division
Are you receiving 40,000 every month?
No, my lord. No,
Please
because
say.
that's what my let me submit, my lord. See, the division bench are clearly directed to pay the arrears of maintenance on or before February 2024. That arrears still has not paid. Another from February 2024 to this year 2025, there's a 1 year due. And moreover, he himself filed an affidavit.
This 5 lakhs will pay when?
5 lakh has been paid, my lord.
Another 5 lakhs will be when will be
within 4 weeks, my lord. That I have already, my lord, requested and your lordship has granted on 24/1/25 itself.
Get the 5 lakhs, then we'll see.
pardon me,
In lieu of the, in order dated 24/1/25, it was inter alia recorded as the court that as per the statement of learned advocate for the respondent, out of amount of rupees 10,30,000, rupees 30,000 was paid on that date itself to the complainant wife, whereas the balance of rupees 10 lakhs to be paid within 2 installments at the interval of 4 weeks each, as per the request of the respondent. Post of today, when the petition comes up for consideration, from a memo dated 27/2/25 filed by learned advocate Mr. Basavaraj Pannur for the petitioner, the respondent, mentions that out of the aforementioned 10 lakhs remaining to be paid, a sum of rupees 5,30,000 is already paid to the respondent, as paid to the complainant in his account number in his account. Full stop. About the remaining 5 lakhs, it was stated that the same shall be paid within 4 weeks from today. The said undertaking submitted in form of memo is taken on record, rupees 5 lakhs shall be paid on or before
2 weeks to me.
to give time. 28th of March. All you keep your calculations ready, both sides, so that if any arrears or current amount is to be paid.
I'll direct the party to know.
Otherwise, this is virtually over.
Please,
Again, I want to. open
this
the
filed
discussion.
only against the order first in division bench, which ordered to pay the arrears till February 24.
No, also 40,000. No?
Yes,
No,
remaining
no,
40%
this
has to be-
contempt is filed only against the order of the passed by division bench in MFA, my lord, 3/2/3/1/21,
Family
which
court
says
has
up to
ordered pay
February
minimum
24.
40,000.
Page.
I am, my lord, the very contempt is filed against the order dated, my lord, 20th March 24.
Correct.
Last page 24, my lords.
Yes.
Clause 2, the appellant is hereby direct deposit and make payment to the arrears of maintenance digitally to the respondent till the month of February 24 within 2 months from today. Here I have paid, my lord, up to August. My lord, now for execution is pending, they can work out, my lord. I am liable to pay till the, my lord.
So once you pay 5 lakhs, we'll.
Please, my lord.
If we granting liberty to approach the execution court, which is already pending, then we can recover from the
Execution is filed
court.
first, contempt is filed later.
Today itself we can close it.
But no,
Yes,
sir,
ma'am.
another installment he has to pay. Though.
Much.
Number 115, Mr. Harish HV.
Sir, I file this contempt, my lord. For change of kata, my lord, from my vendor's name to my name, a direction was given to consider the request within 12 weeks. That's on 8/1/24. Till date, it is not considered. My lord, an affidavit is filed.
My lords, accused number 3 has filed his affidavit on 14/11/2024, please, my lords, along with annexures, please, my lords, wherein an endorsement has been issued, while annexure R3, please, my lords, are the typed copy is at, the translated copy is at page 27, please, my lords. There's any number of writ petitions pending as again filed by the landowners, please, my lords. The entire acquisition proceedings has been quashed. And the layout which has been formed by the petitioners vendors, please, my lords. There is a stay with regard to the entire layout is concerned, please, my lords, which I have placed at annexure R1, please, my lords. The order of the Honorable Single Judge in annexure R1, page number 6, of my affidavit, please, my lords, where there's a status quo order as against all the respondents, including the authorities, please, my lords.
Status quo is granted.
Please, my lords.
Where is it?
I have page 7 of my compliance affidavit, please, my lords. Order dated 13/3/2023, please, my lords. In paragraph 12, please, my lords, on 5/9/2022, this court has also permitted for respondents 5 to 10.
So in view of this order, it might not survive.
No, my lord.
Please, my lord. To that effect, we have issued an endorsement, please, my lords. In pursuance of the orders passed by the Honorable Single Judge in the aforesaid writ petition, we will consider the request subject to disposal of those writ petitions, please, my lords. There is a title dispute with regard to the entire layout is concerned, please, my lords.
That the status quo order has been vacated on 5/9/22. That's which my friend read out now. Only there is an order not to put up construction. My lord, I am seeking for change of kata in my name. Even the directions in this writ petition is also, my lord, a task force to be formed. And my lord, consider the representation and pass suitable orders. My lord, in spite of this, my lord, 8 weeks, my lord, they were required to submit a report. That is from 13/3/23, 8 weeks is given. In spite of that, my lord, even in the other court also, my lord, they were required to consider my documents. Though, my lord, I was not a party there, required to consider the documents of the applicants and pass suitable orders by the task force committee. My lord, within 8 weeks, my lord, 13/3/23, even that they have violated. And the time is extended again for another 6 weeks. That is also violated. My lord, both the court orders is that, my lord, they need to consider the representation and pass suitable orders. That is not being done, lordships. There is no status quo. There is no prohibition for them to consider the change of kata from the name of vendor to my name, which is already there. And I have submitted all the documents as per the order of the learned single judge, lordships.
My lords, the order is subject to disposal of the said writ petition. And even there is an order directed the respondent's authority not to to see to it that no third party interest has been registered before any authorities. It has been reflected in para 13 of
You are appearing before single judge.
no, please.
There.
I did
Must be
not
pa-
appear.
Must be party there.
Yes, please, my lords. But in that writ petition, I have no,
In future, you will be appearing?
my lords.
In future, you will be appearing?
No, my lords.
Why? You are which authority?
My lords, it has been allotted to some other panel advocate, maybe. Yes, my lords.
That's the difference.
And with regard to the delay is concerned, I have explained in paragraph 2 of my affidavit, please, my lords. I was only in charge of the said.
Wait for at least seeing the developments in the writ petition.
Please, lordship.
4 weeks. Let us see what orders are passed.
What the task force
Please.
would do. That would also apply to me, lord.
In view of the
There's also a committee formed in by virtue of the orders
Writ petition
directions
number?
passed by the
Where is
honorable
that?
single judge.
Writ
Writ petition.
produced it?
13945 of 2020.
Oh, yes, here. Number 1394521, which has interactive effect with the subject matter of this contempt petition. Stand over to dependency of new dependency of writ petition number so and so, having interactive effect with the subject matter of this contempt petition. Stand over to 7th April.
Please, lordships.
Great, please.
116.
In this case, I appear for the complainant, my lords.
It is a matter pertaining to mutation of my property with respect to survey number 85 measuring 1 acre 10 guntas by virtue of this judgment passed by the civil court.
My lords, on 12/2/2025, the Assistant Commissioner has given necessary directions to Tashildar. Subsequent to that, Durasti has been done. OD has been done. Only in Bhumi, the Pani entries has to be made in RTCs. If 1 week's time is granted, my lord, there is some technical issue in the Bhumi website, my lords, to enter the name of the, all the process has been completed, my lords. If your lordship have it next week, my lords, have it, my lords. There is order passed by the Assistant Commissioner to the Tashildar, my lords. OD Durasti, everything has been done.
In the mutation.
Everything has been, it has to be only uploaded in the website, my lords.
You have to correct it.
Please, my lords. Next week, my lords, I will report compliance, my lords.
Send over to 19th March.
Please, my lords.
At the request of learned additional government advocates.
Please, oblige, my lords.
Much obliged, my lords.
On which date?
I will report compliance, my lords.
It stated that the compliance of the direction will be reported.
Please.
Much obliged, my lords.
To be listed at 2:30.
Much obliged.
Oblige.
From 120, Mr. Keshav M. Datar.
Lords, 120, I am appearing for the petitions council, my lords.
Yes.
Lords, can I request if your lordships can take this matter sometime during next week, my lords?
No problem.
Yeah.
Next week, any date?
20th March.
Your lordship, since from more than 7 years, my application for conversion is pending. And now in this appeal, due to undertaking given by the government advocate, there was a direction. But in view of the undertaking given by the government advocate, now
So when do
Any date in the next week or week after next, my lord, subject your lordship's convenience.
19th is convenient. If it is not 17th, 17th.
Please, my lords.
But interim order to continue. Send over to 17th at the request of learned advocate. Petitioner. Interim order granted earlier will continue to operate till the next day.
that was the undertaking given by the government advocate. Interim order, that is the
A
undertaking.
form of
given-
an undertaking, my lord, that we will not precipitate.
Your
the-
interim order is operating.
Please,
Continue
madam.
to operate.
Please.
till the next. Great. Interim order clear granted. And in operation shall continue to operate till the next day.
Grateful. 121, Mr. Chandra Tarikaki.
For the petitioner. My lord, on the last occasion, my lords passed an order. On the next date, respondent number 2 shall produce completion certificate in respect of the building state, which have been issued by the town municipality certifying that the building is in accordance with law according to the construction bylaws. And the petition shall be listed on 27.
May I make my submission in this regard, my lord?
Because respondent number 1 municipality had passed.
May I make my? Lord, we have filed, my lord, certain photographs and documents, my lord, before in the, my colleague's wakalat also is not put up, I am told, my lord. But, my lord, we have filed it in the, my lord, registry. Can you give me a copy, please? There, huh? I told you to keep 2 copies ready. May I just, Lord, your lordship will just have. Must. It's filed today. It is filed in the court.
You are for number 1?
For respondent number 2, ma'am.
2. Who is?
For respond number 1, ma'am. I'm for respond number 1.
Who is number 2?
Lord, he's a private individual.
So it is, what happened to demolition?
Lord, may I just explain it?
Respondent
Just give me
number,
one,
respondent number
please.
one need to answer.
Then please give this document. Lord, we have filed it today, Lord.
A copy may be given to me also.
Copy, give copy.
But Lord, unfortunately, my colleague Lord has brought only one extra copy.
Then give after I'll take up. First, write of your
Yes,
learner.
Lord, I will just show one thing, Lord, why we are not unable to produce completion certificate is for this reason. Your Lordship have page 6 in this compilation.
Give copy.
My lord, it should not matter.
We'll share with you. Not if you-
I have one small memo.
The photographs are
supplied by
relevant. Can have.
Thank you.
What is your say, Mr.?
My lordship,
What is your say?
my lordship, they have to produce the completion certificate.
Lord,
Let them produce the completion
You are
certificate.
supposed to issue completion.
no, please, Lord, please have page 6.
It's without license. My lord.
Correct, I
That's-
admit
that's
it is
the-
without license. I'm
that's the
going
reason.
to make, as an officer of the court, I'm going to make a responsible submission to your Lordship. Lord. Kindly have page 6.
Page?
Page 6 of this compilation that I've just handed over now. Lord, this was the building which was existing, my lord. This building was about 53 years old, my lord. Now, my lord, your Lordship will see the next page. Lord, today's situation, my lord, is at page 7. So in fact, my lord, the first and second floor was demolished. And my lord, only the ground floor was retained. And my lord, this work was given to a local contractor who said that I will get the licenses and do it. But before he could, my lord, apply for the licenses, my lord, this writ petition was filed. And my lord, in deference to the stay, my lord, we have not constructed, we have not even put one brick after this, my lord. From 2020, that's what I was, my lord. In fact, I was laughing at my client. I said, look, all you have to do is give an undertaking to the court saying that I will apply for the building license and my lord, I will comply with the building bylaws. But I'm making that submission today before your Lordship, my lord, because this, Lord, I thought that already the building is constructed, but your Lordship will see, my lord, it is only demolished. What was there was demolished, and then, Lord, the only person who could have had a grievance is the wine shop owner, my lord, who was removed from that shop.
Page,
Page 6, my lord, his wine shop is there. He was removed from there. Now, he has, my lord, orchestrated this entire litigation. And 5 years, my lord, we have wasted.
page 7 is new construction.
Page 7, my lord, is today's situation.
New construction.
No, my lord, only the ground floor, as it was there earlier, it remains, my lord. The other, my lord, thing is, my lord, is a new construction. They should have taken a license. They should have taken.
Same structure as it existed earlier.
I'm so sorry.
Page 7 is the same structure of the.
It's the same structure, my lord.
Same structure.
Same structure.
It has not been demolished earlier.
That has not been demolished.
My instruction is otherwise.
And my lord, your Lordship will see.
Even then you have to take the.
Yes, my lord, I totally agree, my lord. Your Lordship may kindly see page 8 also, my lord, for a minute. Now, my lord, the building in the foreground, my lord, is my building, which is much behind the adjacent building, my lord. So the line of the road also, my lord, is not being affected. Then your Lordship will see the next page, my lord. On the other side also, my lord, your Lordship can see the building, my lord, abutting, my lord, outside than my building, my lord. And my lord, your Lordship may see page 11, my lord, and 12. Lord, there is sufficient setback also, Lord, because it is an old building which has only the ground floor has been retained, my lord. And my lord, if your Lordships.
Because originally like this. No, the demolition is.
I'm giving an undertaking, my lord.
Have you get some plans sanctioned?
No, my lord, I'm
No,
giving an undertaking. I will not proceed.
No license.
I am
no
admitting
plan.
it.
Now,
I'm admitting
now
it,
they
my lord.
say that after construction, that
Where is the
now we will
construction? There's
apply
no
and
construction.
get
Now,
these.
Mr. Ariga,
Please, madam.
his contention is, come to page number 6.
Please, madam.
Come to page number 6.
Yes.
That was the earlier construction. That was the earlier construction, which stood there in that manner for several years. Page number 6. Now turn over to page number 7.
Please.
He voluntarily removed the top floors with a view of altering the building. And this is the present construction. When this was the situation, you filed the writ petition.
My lord, I will, this is supplied
Very
to
well,
me
Lord, let it
now.
take.
I will get instruction.
And now his undertaking is, he will not add a brick to it without obtaining the necessary licenses and permissions.
If your lordship.
I will,
And if the
Yes,
licenses
Lord.
and permission warrant even altering the structure as at page number 7, he will do it. That's his contention.
I will come back. I will come back because this is given to me just now. I will come back within 3 days or 4 days. Kindly have it next week. Because without instructions, if I were to make a statement that this is a new construction, may not be correct. I will get instruction.
True, my lord. I mean,
I will get instruction.
my friend may take instruction.
Even if it is a new construction,
Please.
the council undertakes that before putting up any further brick, they will get the plan sanctioned. Thereafter, they will proceed to construct further. And will direct the municipality to examine and give the completion certificate if it is in accordance with the sanction plan.
If it is in accordance with the sanction plan, and also my lord, the sanction plan should be in accordance with the bylaws.
Bylaws.
That's
Obviously, my lord, that
therefore,
goes
kindly,
without saying.
yes,
goes without
yes. Therefore, he says now everything is all right, setback is correct, all that. I will get instruction 3 to 4 days. Kindly have it on Tuesday, my lord. I will come with the instructions, make a statement.
Since affidavit is filed by the,
Lord, it's not an affidavit, there's a memo, my lord. I will convert it to an affidavit and put it.
you better convert in it.
Yes,
Or you file your affidavit stating that we will
yes.
get. Since memo is filed, producing certain documents and photographs, learned advocate for the, since memo is filed by respondent 3, who is learned advocate, senior advocate, Mr. So-and-so, containing certain details and the photographs, learned advocate, Mr. So-and-so, for the petitioner 6 time to take instructions, put up at 2:30 on 11th.
Lord, my friend's name may be shown in the list. This
Wakalat has been filed, but it has not been put up.
With learner senior advocate instructed by learner for number 1.
Acknowledgement.
Grateful, my lords.
Number 24.
Your Lordships, I accept notice for, Your Lordships, I accept notice for Karnataka State Pollution Control Board in this matter. The name of A. Mahesh Chowdhury may be reflected, Your Lordship.
Why did we issue notice? We have not
Oh,
issued notice.
Apologies, Your Lordship.
It is a fresh matter or notice is issued?
It's a fresh matter.
Fresh. What is it about?
My lord, I have sought for writ of mandamus to not to take any penal action till the disposal of my appeal, which is pending before the appellate authority.
So what is wrong in it, Mr. Pollution Control Board? What is wrong in it? What is wrong in the prayer? If appeal is pending?
Your
If
Lordship,
appeal
my
is
instructions were
pending,
to
what is
accept
wrong?
notice.
You have got the copy of
I
the
may seek
petition or not?
instructions and
You have got the copy
not
of the
yet, Your
petition?
Lordship.
Hmm?
Not yet, Your Lordship. Not yet, Your Lordship.
I have served the copy.
Notice returnable on 17th March to be listed at 2:30, having regard to the limited nature of the prayer made in the petition, full stop. Learned advocate, Mr. So and so, may serve copy of the petition to learned counsel for the respondent Gujarat Pollution Control Board in addition to serving, in addition to effecting service by normal mode.
Till such time not to precipitate the matter.
They will not, don't take any action.
Obliged, Your Lordship.
Learned advocate for the respondent board who appears online asking for copy of the petition states that they will not take any precipitatory action till the next date.
Much.
It is so directed.
So number 25.
First time, Madam Lord, that I have challenged the rejection order of my application, which is filed for under section 31 ZC of the Karnataka Minor Minerals Concession Rules. Lord, ink page number 50 is my rejection order.
Not appealable. Appealable.
This is, my lord, the rejection order passed by the state government. That is, my lord.
Where is that?
Director.
Director, yes.
Director.
52.
52, 53 will not come because, my lord, director, joint director, my lord, we cannot approach.
So 52 is the order, impugn order.
Yes, yes.
Not appealable.
Revision is there, my lord.
Revision, my lord, insofar as that this is concerned, my lord, joint director, since, my lord, the kindly see the order. First, annexure F, ink page number 46, translated copy, is ink page number 48, my lord. This order came to be passed by the director of Mines and Geology. If we have to appeal, joint director Mines and Geology, my lord, the Ballari, we have to go. He is below the rank of director. Therefore, my lord, that we have to approach this court. This is above the rank of 53 will not attract because, Lord, this order came to be passed when they have sent for approval. Kindly see 53.
Yeah.
Full 50. Rule or section? Section 50.
Karnataka. The competent authority is deputy director or senior geologist.
Under sub rule 2, it will be meant.
Yes, my lord. 53-2.
Who is the relevant authority to whom the revision lies?
My lord, it's the secretary, government.
Noted.
Myris.
The director is not the state government here.
A director is not the state government,
No,
but
it is not on behalf of the state government.
No, it is by the director, my lord.
No,
And
that-
yes,
Therefore, revision would lie before the.
yes.
state government that has to go, but provided, my lord, there.
Or it is a delegate of state government in that sense.
The
become a state
principal
government.
secretary to the
Yes.
Mines and Geology Department, that we have to go. Principal secretary, Mines and Geology Department.
Yes, the regional authority, higher authority.
Higher
central-
authority is the government principal secretary. Therefore, my lord, that I'll make out the case for rejection. Application which is, my lord, all NOC has been objected.
Why don't you make out the case in the revision application?
Please, my lord.
To make out your case in the revision application. What do you want? Time.
No, my respectful submission, your lordship is, can heard, if your lordship is hearing, then, my lord, since, my lord, it will take, under those circumstances, I am requesting your lordship, let them file objections to this rejection order.
No, we are saying that you go with the revision by filing revision. That is what we are suggesting in view of 53(2).
Principal secretary to the.
Revisional authority, whichever.
If
is
your
the-
lordship directing to consider and pass orders within 3 months, I'll make application within 1 week and let them consider within 3 months or 4 months with that direction, my lord.
My lord,
Otherwise, my
we
lord,
set a
there
precedent
is
in
an
all the
instance for
matters.
14 years that we have waited. That is also there before your lordship. Under those circumstances, if your lordship is directing within stipulated time, then, my lord, I'll withdraw and, my lord, since that is the worry before the government, that's all.
My lord, within 90 days, they had to file a revision. My lord may see the order, it is dated 25/6/2024. Writ petition is no date for the writ petition.
17th September 2024, that we have filed immediately after receipt.
There's no power to condone.
Please, my lord.
My lord, they do, the authorities do consider applications.
So
which
you
are
withdraw and will give you appropriate direction.
If your lord, I am withdrawing, provided, my lord, stipulate, if may application is made, let them consider, my lord, pass orders within stipulated, whatever time your lordship picks.
Having realized in course of the submission that revision application under Rule 53, bracket 2 of the Karnataka Minor Mineral Concession Rules 94 is maintainable against the impugned order which is passed by the director. From a learned advocate, Mr. So-and-so seeks permission to withdraw the present petition, stating that the petitioner would approach the revision authority by filing appropriate revision application. Permission is granted to withdraw the present petition, to enable the petitioner to avail the statutory alternative remedy of filing of revision application as above. Full stop. It is clarified that this court has not expressed any opinion, nor has not gone into the merits, nor has expressed any opinion on merits of the case of the petitioner. Paragraph.
No.
Revision application, if filed, may be disposed of by the revision authority, preferably within a period of 6 months.
Please.
6 months,
My lord, we set a
Yes.
precedent in all matters.
preferable.
This, my lord, direction to the revisional
Right.
authority.
Well,
My lord, they may, if they cooperate, it might get disposed of earlier.
What is
also.
the problem?
At this stage, learned advocate for the petitioner submitted that the revision may be treated as time barred. It is observed in this regard that time spent in prosecuting this petition shall be treated as indicating bona fide by the petitioner and shall be accordingly treated by the revision authority if an application is made in that regard. Full stop. Learned advocate further submitted that the timeline may be fixed for the revision authority to dispose of the revision application. In this regard, it will be open for the petitioner to request the revision authority to expeditiously dispose of the revision application, which shall be duly considered by the revision. With the above observations, the petition is disposed.
Pleasure.
As withdrawn.
Seal number 26, Mr. Shivkumar
For
KV.
the petitioner in this case, please, my lord. The petitioner is seeking for a writ of mandamus, my lord, to consider his representation, my lord, which is at annexure A, please, my lord. Consider his representation, my lord, dated 7th August 2024.
Shall I dispose of or you will take
My
it?
lord, I'll take notice. My lord may have it after 10 days, my lord.
Notice returnable on 18th March to be listed at 2:30 in view of the compass of the prayer.
Please. Date.
About which learned additional government advocate. Srimati Nilofer Akbar will take instructions.
Yes,
Date, my lord,
18th
Huh?
March.
18/3. Obliged.
Notice. Okay, so not complete. Pursuant to order dated 15/11/24 passed by the court, report is submitted by the register is considered, full stop. If any of these officers are still to be complied with, the same shall be complied before next date.
I have completed them, my lord. Office subjects are,
Then further order, whatever dictated.
office objections are complied by me. Obliged.
27 to 29 are urgent. Seal number 30. To Vivek AM.
Here for the petition.
Sorry.
Petition, my lords, is challenging the order passed by the first respondent State Pollution Control Board. A similar matter, my lords, had come up before this honorable court last week. My lords was pleased to order notice and the matter was posted on 26th March 2025.
Which is that matter?
Writ petition number 4820 of 2025, my lords.
It was stated by learned advocate Mr. So that similar writ petition number 4820 of 25 was posted before the court, which was treated by issuing notice.
Right.
In that we also in this petition, there shall be notice returnable on
26/3/2025.
26/3/2025. Learned advocate Mahesh Chaudhary appears all of a sudden and accepts the notice. Accepting notice.
Yes, I accept.
31.
31 also same, my lords. 31 also same, my lords.
31 also same, very good.
Please.
Great. Don't write all of it.
Thanks, Felicia.
32, 33 are urgent. Seal number 34, it's repeat. Mr. Sappananavar Authorized. 34.
For the petitioner, my lords.
Delay.
My lords, I filed an application for continuation delay of 355 days, my lords.
So
My lords, the appellant is a government body, my lords. So, my lords.
anybody is appearing? Is
See, my
after,
lord. For the
Take
appellant,
notice
my
for respondent number 2 and 3, my lord.
after notice? Not. Yes, matter, then notice. Who are the other parties except state government?
My lord, respondent number 1 notice may have to go.
Private parties are there? Yes.
Yes, my lord.
So notice returnable on.
My
2
lord,
and 3, I will take notice.
my lords, I've also filed an application for stay, my lords, because the respondent number 1 has initiated contempt proceedings before the KSAT already, my lords. And I have complied the rules as per Karnataka.
Madam, unless the delay is content, we can't pass any order.
Please.
You tell the contempt court that appeal is pending. Notice returnable on 28th March.
Great.
Number 35. I appear for appellant, my lords. It's a delay of 32 days.
But it same notice returnable on 1st April.
Because I may be permitted to serve on this council who appeared in the writ petition.
It is learned counsel of the petition is permitted to serve copy of the petition to the counsel of the respondent who appeared before learned single judge in addition to normal mode of service to be effected personally on the respondent.
Seal number 36. Mr.
Same
Suresh, 19 days.
notice returnable on 7th April.
My lords, I may also be permitted, my lords, to serve the copy on.
Same order.
Great. Seal number 37. Mr. Muralidhar HM. 37.
93 of the issue notice. Notice written evidence, 8th of April.
Number 38. H.N. Basuraj.
38.1 and 38.2. It is to be heard, my lord. Last occasion it was there. We had taken time yesterday. It was before the other court. It get given today, my lord. Could it be on tomorrow, my lord? Some urgency, it's an election matter.
I'll take notice, my lord, in this matter. There's an application, my lord, which the learned single judge passed an order extending the time for conducting the election. That has been impugned in this writ appeal, my lord. I would request for some time to secure instructions, my lord. We will. The appeal has to be heard out, my lord. It's only on the interim application.
Question is, my lord.
On the interim order, my lord.
Earlier, there is a direction by the learned single judge. Election was in process. It was interrupted because of government order in view of the parliamentary elections. Then after completion of the election, it has been clarified. Process to be completed from the stage where it is interrupted. Then learned single judge considered the matter and directed to complete the election process on or before October 2024. If the learned single judge order is executed, by this time, election could have been completed about 4 months ago. After 2 months and 2.5 months later, they made an application for extension of time. At that time, our contempt is also pending before your lordships. The reason assigned by them would not be the reason to seek extension of time. We opposed that. Learned single judge granted 4 months time to complete the election process. That my lord are also challenged before your lordships in the writ appeal, and contempt is also tagged. That he can take, we will serve the copy is already served. And matter could be heard on Monday at 2:30, my lord. It takes only 15 minutes, my lord. We will close the things. Monday. Yes, Monday.
We
Could
need
it
some
be-
time to secure instructions, my lord. My lord, this is only an order extending the time by 4 months, my lord, which the learned single judge has considered and granted four months time to conduct the election, my lord, on our request.
In
Page
September,
41.
my lord,
Page 41 is the order, my lord, where 4 months time has been granted. Last 2 lines, my lord. Page 41. On our request, my lord, the time has been extended.
But they have objection.
Yes, my lord. Monday, my lord, it's your lordship
been
may
extended
kindly
for-
consider.
According to it, should be extended for 6 months.
My lord, but the very extension we are opposing because
Only the
reason for shown by the learned single judge and they sought for an extension on such reason would not be available because it is regulated under the government order. my lord.
But
They-
extended time has already started.
Beg your
1
lordship.
month is over, my lord.
Anyhow, we will make a listed Monday, my lord, we will certainly assist.
Sometime week after next, my lord.
Right. It is everything
after
is
next
part of the record. It is the part of the record. And everything is to be decided based on the records available if your lordships only. No instructions and then every fact is well within their knowledge. You have placed all the materials also. Your lordship may kindly list it on Monday, my lord, we will argue. If your lordship feel it requires a time from the other side.
We
then your
never, right from the moment we are not feeling any.
Very well, my lord. If that is the reason, may be listed on Monday at 2:30 or fresh matters category in the morning itself. We will take only 15 minutes, my lord. We could be able to pursue your lordships in that context.
Time offer feel that many matter doesn't require any time to decide. But if you are seeking time, then we'll grant time.
Monday at 2:30, my lord.
Tuesday.
Very well. Grateful. Tuesday at 2:30 or fresh matter category, my lord. 2:30 or fresh matter category.
Whenever you want, looking to the nature of the order 2:30.
I leave it to your lordship. Grateful.
We'll take up on 2.
Very well.
Better for you that it is taken up late. Better for you, it is taken up belated.
Anyhow, we will be here. We will take a chance on that.
All.
This number 39.
My lords, in serial number 39, I appear for the appellant bank, my lords. My lords, I have some inconvenience today, my lords. Could it be taken up next week, any date?
Which ones? 41?
Serial number 39, my lords.
49. Hold it. When do you want?
My lords, next week, any date, my lords.
Next week, 19th of March.
Please, my lords. Obliged.
As requested by learned advocate for the appellant.
Number 40.
I appear for the appellant. The appeal, my lord, by the Union Bank of India, my lord. Lord, we had issued certain bank guarantees in favor, my lord, of the respondent.
Yes.
Lord, two bank guarantees, my lord, had been issued by the bank in favor, my lord, of the respondent here. The bank guarantees, my lord, they claim was sought to be invoked. The original petitioner claims, my lord, that they sought to invoke the bank guarantees and that the bank did not make payment of the money. Our case, my lord, was that there was really no invocation because the invocation had a particular mechanism by which the invocation had to be done. It had to be done by way of a letter addressed to the bank and delivered at its office with the original bank guarantee. What they did is they say that they sent an email, and that email should have been treated as an invocation of the bank guarantee. Well, according to us, it was simply initially a letter asking us to extend the period of the bank guarantee, not an invocation. Now, all these questions were gone into by the court, and court says, and the learned single judge holds that there was an invocation of the bank guarantee. Bank deliberately did not make payment, and therefore, my lord has asked us to make payment of the entire bank guarantee amount with 18% interest and 5 lakhs cost. I'll take your lordships to all of this, the facts. Will practically, various disputed questions have been examined by the court and answered, saying that there was something dishonest in the stand of the bank in refusing to honor the invocation which was made by email. I thought the law was that if a terms of the bank guarantee have to be strictly construed, and every action that is taken has to be in terms of the bank guarantee. Now, whether that email could have been sufficient to hold that it is an invocation or not is also one question which requires to be answered. And in this case, I'll show your lordships the document. The bank guarantee itself, bank guarantee has a specific mechanism by which the bank guarantee has to be invoked, and that has admittedly not been followed.
Where is the order of ombudsman?
My lord, order of ombudsman is simply that it is not within his jurisdiction to deal with this issue.
That's all.
That's all. He says, I have no jurisdiction to deal with this issue. The court could have said, you have jurisdiction, which is the finding, and then directed the ombudsman to consider it. Because the complaint was made to the ombudsman. Ombudsman said, I have no jurisdiction on matters of this kind because they are commercial in nature. They don't deal with any particular mistake on the part of the bank. Therefore, I cannot decide that question. That was challenged before this honorable court. This honorable court hold that, no, it is wrong. Ombudsman has the jurisdiction, in which event the matter should have gone back to the ombudsman for decision. But the court then went and said, now your invocation is dishonest. The finding is...
It is so held by the learned single judge.
Yes, yes.
Ombudsman is jurisdiction.
Yes, yes.
He holds so. Then he proceeds to decide.
Then he proceeds to decide the question and then says, bank guarantee was properly invoked. It could have been invoked by an email. And then says, you have to now pay with interest at 18%. And not cost of 5 lakhs because learned single judge concludes that my conduct is dishonest as a bank.
So now the bank guarantees are already invoked.
Bank guarantees not said to have been invoked. According to us, it was not properly invoked. It was not properly invoked in terms of the bank guarantee.
They are encashed.
So that's what I'm saying, that encashment had to be done in a particular mechanism.
Now, what can be done at this stage? How to reverse how to set the clock back? Even if you are right.
Beg your pardon, Lord?
Even if you are right.
If I'm right, Lord, then there's no invocation. If there's no invocation, there's no obligation to make payment.
Then it is already paid. My payment is
No,
made.
we've not made payment. I am the Union Bank of India. I am the bank, my lord.
Not paid.
No, not paid.
That is what we are asking.
Yes, we never paid that money. No, my lord, this is not as a regular bank guarantee suit where the person who caused the issuance of a bank guarantee comes to court and says, restrain the invocation of the bank guarantee. Here is a case where the bank guarantee they claim is invoked, we claim is not invoked. We say, therefore, we did not make payment. Therefore, the question, my lord, is whether the conduct of the bank in not honoring the so-called invocation was right or wrong. That is the question before the learned single judge, which is why they went to the banking ombudsman, saying that the bank is not honoring our invocation. So the petitioner, my lord, or the appellant before your lordship is the Union Bank of India, which had issued the bank guarantee.
Then we proceed to hear.
Yes.
Give the facts.
Their sole ground is, my lord, email, my lord, cannot be used. In fact, my lord, the learned single judge went into the whole thing. It is not their case, my lord, that the bank guarantee requires, my lord, the original bank guarantee to be furnished. No, only invocation. Please look at the bank guarantee itself. My learned friend is not right.
But let me finish showing.
Because my learned Chief Justice asked, Honorable Chief Justice asked, I am. Oh, I'm sorry. My profound apologies, my lord. I thought your lordship wanted me to.
Shall we start the hearing? So then
Yeah.
give the facts. That is what I.
Yes.
Very well. Lord, your lordship. My arguments are very interesting, my lord. Time flies.
So you
Time
people
got
are
felt.
arguing so nice
got
that we
felt, my
forget
lord.
the time. You people are arguing so nice that we are forgetting time. So when?
Relax.
We've not felt contempt.
Person who has furnished the bank guarantee is not made a party.
No, he has no role to play. He went into
Person who has
liquidation.
issued the bank guarantee is the bank only.
No.
Okay. He has no objection.
My lord, it's not relevant at all. He has nothing to do with
Who
it.
are you?
I am, my lord, the beneficiary of the bank guarantee. That's all that I am required.
Beneficiary.
Yes, my lord.
They are the beneficiary of the bank guarantee. I am the issuer on behalf, my lord, of a particular contractor.
My lord, please look at.
Peculiar kind of dispute.
It's a slightly different
No,
situation.
with the greatest respect,
No, it's
if
not.
your lordship look at the bank guarantee, it's only, my lord, between me and him. Third party does not come into the
No,
picture.
I'm not.
Of judgments of
No,
Supreme
my
Court.
case is not that a third party should be there.
He is on the mode of invocation.
It's on the mode of invocation and
Invocation, my lord, email, my lord, their sole case was email, my lord, the invocation is not proper.
No.
IT Act, my lord, Information Technology Act, my lord, enough judgment of the Supreme Court where they have held invocation or, my lord, any notice issued by means of a email is sufficient. I'll point out that. That's the issue.
no, there are two, three
That's a
issues.
short
Not,
issue,
it is
my lord,
not
for my
as
lord's
simple as that.
consideration.
What did you first do? Did you ask for invocation or extension?
Minus interest and cost, I think you should not have any
All
problem
right,
now.
I leave it at that. I don't want.
I'll find out then. I'll find out. If
That
it's
resolves the entire dispute. Minus interest and cost,
All right,
you can't have any grudge.
I'll find it. That I can find.
all right. I leave it at that.
I'll find out. Minus interest and cost, I can find out. I'll check them with them.
Please.
Lordship may have it on Monday or Tuesday. I'll check with them. If that's the case, then I can put an end to this. Right. No, I'll take your lordship's advice on that. Monday, your lordship may have.
Monday you want, not Wednesday.
Wednesday then. Or Wednesday. Wednesday.
So many matters are.
Yes. Wednesday.
That is the only.
Yes, Wednesday.
Grateful.
Lordships kindly, my lord. Serial number 83, my lord. 83, my lord. Government appeal, my lord. There's a contempt listed for tomorrow, my lord. Requesting it to be tagged along with contempt and taken up tomorrow, my lord.
Tomorrow.
There is substantial compliance also. I will make
Tomorrow
my
may not be posted.
tomorrow along with the contempt matter, my lord. Contempt is listed tomorrow.
If you don't take up contempt tomorrow, then.
Now let appeal be considered, my lord. The reason is, my lord, there's an order in the contempt for compliance to obtain an necessary interim order in the appeal, my lord.
We'll put both on Tuesday.
Well, contempt is scheduled for tomorrow.
We'll put it on Tuesday.
Very well, my lord. Because there's a direction for the director to appear in person, my lord.
Mention it in the name of contempt petition that appeal is filed.
Please, my lord.
Appeal is going to be listed on Tuesday.
Please, my lord.
We'll list the contempt on Tuesday.
Very well.
Lordship, serial number
My lord,
80.
serial number 42, my lord. 42, my lord. I pray for a Monday, my lord, Monday. There is a delay.
Monday, yes, but which Monday?
Coming Monday. My lord, there is a delay also in preparing the appeal.
Delay,
Delay.
fresh matter.
Fresh matter.
Notice returnable on
Please,
1st April.
please. They have filed contempt, my lord. I will mention on that.
How you mention?
Please.
My lord, serial number 60, my lord. Your matter is urgent. It may be posted on 3rd or 4th of March, my lord. Please, my lord. My lord, appeal itself will be withdrawn, my lord. Appeal itself will be withdrawn if I got the relief on administrative side, my lord. I have given the representation on administrative side and reply is given. Prior is pending. Therefore, I have moved the application for amendment, my lord. If it is permitted, it is sufficient, my lord. Please, my lord, it may be posted on 3rd or 4th, my lord. Please, my lord.
Amendment application.
Yes, my lord. To delete the prayer. Please, my lord.
17.
Please, my lord.
Serial number 67.
Serial number.
Serial number 80, my lord, it's a transfer matter, my lord. I have been displaced by virtue of the order passed by learned single judge. The order of transfer was cancelled. That was set aside by the learned single judge. The only transfer matter, my lord, in serial number 80, my lord.
What do you want?
I'll be displaced from my place. I am displaced by virtue of the learned single judge.
So what do you want? What do you want?
I want the a date, my lord, nearest date, my lord,
You
because
nearest.
my lord.
Serial number
Sorry, my lord.
Serial number 67, my lord.
My lord.
80.2 already served the council, my lord, through 80.1 also same order may be given. I will.
68.
Serial number 67, my lord.
611, my lord. 68, my lord. Because I'm 14%. I have engaged a lawyer.
Serial number 46, 14%. Maybe next week, my lord.
Take the date now.
67, my lord. My lord, serial number 67, my lord.
14%, my lord. I have engaged a lawyer now and it has to be, please post it on 17th in the afternoon. We are there engaging a senior lawyer also.
Very good.
Serial number 45, my lord. Serial number.